to 6.
Yes.
Item number 6 of the daily list to circulated in adjournment business. Lordship, can I pray for an earlier date sometime this week? Your Lordship?
Either you argue the matter or you take the date which is given by the bench.
Lordship will take whatever is given by.
2nd April.
Much obliged.
So, and for the rest. Yes.
Item number 7 to 18, adjournment request.
Made his lordship. Lordship, in item number 10, lordship, the honorable court directed to bring certain documents on record, lordship. Lordship, I pray that lordship will file the affidavit within 2 days, lordship. Sometime may be granted, lordship.
What is it? What is it?
Lordship, certain documents directed to bring certain documents on record, lordship. I pray that sometime may be granted, lordship, to bring them on record, lordship.
You have brought them those on.
No, lordship, lordship, we have a compilation, lordship, but which is not on record, lordship. If lordship gives the liberty to file this,
As paid for on behalf of the appellant
lordship.
for completing the records of the appeal. Come on. What did I say? Matter is this case is adjourned to give a date after 3 weeks.
22nd April.
Yeah.
Bless.
That is now Pradhan.
Lordship, before that, lordship, if it's possible before that, lordship, first week of April.
You just heard, either you argue today or you take the date given by the, anyway, can it be accommodated? All right.
8th of April.
Deeply obliged.
May it please the Lordship.
Yes.
Lordship, item number 11 for today's list, my lord.
Yes.
Similar matter is fixed on my lord on the 24th of March to retable 2000 of.
We remember Operation Blackboard regularization.
My lord, my lord, my
So
lord,
we have put a whole lot of matters there, cluster of matters.
my lord.
Item number 12, 11 and 12. Let these two writ appeals be listed along with, give the reference.
My lord, 200 of
Along with, so
2022.
on which date?
On 24th of March, my lord.
On 24th of March.
My lord, another matter was pending similar, my lord, retable 140 of 2020. Then maybe also listed.
It's not here, no?
Not here, my lord.
You must think.
My lord.
May I please, Lordship?
Yes.
I get to mention item number 17, Lordship. One connect 1717, Lordship.
7.
Connected.
Appointee was removed.
Remove, Lordship. Connected retable is pending before this honorable court, Lordship. Which is fixed.
What is that?
Another retable, Lordship, out of
It has been filed on whose behalf?
same petitioner, Lordship.
Why two writ appeals?
Initially, we have challenged our approval of the
Let this
final
writ appeal be listed along with
the
other
retable 46, 2026.
on, as a date is fixed there.
Date 24, 4, 2024.
On
24 April, Lordship.
24th of April.
April.
Complete your sentence. A half sentence you keep inside your throat. How do I hear?
Sorry,
24th of April.
April.
Yes.
Obliged.
May I please, Lordship? Lordship, I beg to mention the PPC number 6253 of the 2024. Can you direct to list the matter either on 8/5/2026 or 15?
Get to one with the mention.
Not today, but it was listed. Lordship,
Council, please wait. We are not taking on.
Lordship. Obliged.
You're in a hurry. You're in a great hurry.
Item 19 to 31, adjournment request.
Item the 21, my lord, some
Okay.
21, my lord.
Item number 21.
Some instruction is required, but some matter will be coming next week, my lord.
As prayed for by Mr. S.K. Mary, Leonard CGC. The case is adjourned to your date after 3 weeks.
6 April. From item number 32 to 35, adjournment request.
Lordship, I apologize, Lordship. I heard 21, Lordship. I have to mention item number 27 of today's.
Yes.
With the consent of my Lordship, Mr. B. Gogoi, the additional AG appears. Lordship, there's some difficulty only for today, Lordship.
Lordship, may I pray for fixing it on 23rd, Your Lordship? Regularization of grade for employee, Your Lordship.
All right.
It has been pens.
We can say as jointly prayed for. As jointly prayed for is this appeal on so and so. Whatever date Mr. Board Thakur suggests.
Date level.
23rd.
May it please your lordship, I apologize, lordship. I beg to mention item number 31. I have submitted an adjournment slip, lordship.
Adjournment slip has been sent. All right, we give you a date. Take the date.
Lordship.
28 April. 28.
Item number 9, we'd like to bring on record, my lord, affidavit in reply, my lord. Item number 9, my lord.
When these series were being mentioned, where were you?
9.
My lord,
You want item number 9?
9, my lord. We'd like to bring on record.
The hearing orders, let it be called out.
My lord,
Let it be called out.
Yes.
Make a mention. I
not received a copy.
my lord, that is on the process, my lord. Learned counsel is coming from Delhi, lordship, kindly allowed to, my lord, bring on record that affidavit in reply, my lord.
What do you want?
My lord, affidavit in reply, we'd like to bring on record, my lord. Today we have filed. Yes, my lord.
Yes, we have. Kindly serve a copy.
Yes,
You haven't served a copy.
No, my lord.
my lord, that is on the process.
Then how can it be?
Today we have filed, my lord. Now copy will
Today
come.
you filed. So that the matter will be.
My lord, copy, my lord, will come, my lord. Just within.
We can't allow councils to take the other side counsel by ambush. You file it today, you want it to be argued today. And a council, and you take the plea of a council coming from outside. Is it proper?
My lord, sorry, my lord.
Is it proper? Aren't you embarrassing the council from the outside?
Your Honor, may I submit, please?
Yes.
With the permission. Your Honor, this new, the counter.
What is this piece of mentioning in cases which are listed for orders? We'll see when the case is called out. Wait.
Any other request?
May I please your lordship?
Yes.
May I please your lordship? Lordship, I beg to mention WPC number 6253/2024. On last occasion, last date, it was listed on 16/12/2024, lordship. Order is passed by your lordship's predecessor. So it was reflected that list the matter for hearing in due course of time. Till date, the matter has not
Due
been.
course is due course.
Due course, lordship.
You can.
Actually, my problem
We have
is
followed
that.
it. We have followed it. We'll have a date given, otherwise the case gets detracked. You know, you should not say predecessor. You say this bench.
Yes, yes. Lordship,
There's a great
that is my
continuity
mistake. That is my
of
mistake.
this bench.
Lordship, what happens? I'm removed from railway service after entering my.
Doesn't matter.
Yes,
Now
that's
it
why I'm
has to come on list.
my humble request. My humble request before your lordship is kindly list the matter. Kindly direct to list the matter on 8/5/2026 or 15/5/20.
18 or 15, 5.
18, yes, because I will be standing on
We were thinking of giving you a hearing tomorrow.
tomorrow,
This
lordship.
is the problem of mentioning. The moment you mention, we get ready to argue. We get ready to hear the argument.
Tomorrow I can, but I have other matters also. I'll be standing on my list, lordship. That's why. If lordship will permit, I'll argue.
Why will I not permit you?
Lordship, yes.
Bring it
Last-
to hearing.
last-
We will do it
last-
if the matter is accurate. Anyway, put it on the first date that he has suggested. Let this-
8/5/2026.
8,
Highly obliged, lordship. Highly obliged.
May please. I will mention for withdrawal tomorrow, my lord. One repetition I need to withdraw, my lord.
Tomorrow.
Your lordships, I beg to mention for listing of an interlocutory application. It's a delay condemnation petition, your lordships. However, there are certain
Delay of how many days?
48 days.
48 days only.
Yeah.
All right, tomorrow.
Much goodness.
May I please your lordship, I have to mention for listing for withdrawal, lordship.
Tomorrow.
Daily list for orders item 1.
Yeah, please. Lordship, order was passed almost 2 years ago, my lord. Till date, not complied this order, my lord.
But I'm praying for 15.
Just Mr. Patniar, you made a promise to us.
My lord, I'm praying for 15 more days, my lord.
Why?
Roster registration has already been approved, my lord. It is in the directorate level, my lord.
Aren't you in contempt now?
Only 15 days.
Clear contempt now. Today. We gave you a long rope.
Yes, my lord.
Did
That,
we or did we not?
yes, my lord. That I understand, my lord. In fact, it was approved on 7th, my lord.
Please don't ask for any further time. Either you say that we are challenging this order before the Supreme Court, or you comply with it. 2 weeks more you're asking, we are giving you 3 weeks more. Don't come with this plea again.
Yes, my lord.
All right, as prayed for by Mr. Khatmiar, learned advocate. Come on, the matter is adjourned to after 3 weeks, date though. Mr. Khatmiar assures this court that the judgment of this court shall be complied with in letter and spirit.
Obliged.
9. Item 2.
My lordship,
Yes.
actually, my apologies, lordship, on the last occasion, we were asked to take steps on the private respondent. Some inadvertence, it could not be taken, we'll take it, lordship, today itself.
You have not taken steps?
Yes, lordship.
No.
Yes, lordship, I'm sorry, lordship, we'll take it today itself.
All right. Again, no step taken for issues of notice to respond. Up till now. We'll have counsel to issue, but that step shall be taken by the day for the issues of notice to respond on time. If requisites are filed by today, let notices be issued to respond number 5 by both modes, returnable on each that date, we will tell you. It further appeared that other respondents have been served, but no counter affidavit appears to have been filed on them. In case so deemed necessary by other respondents, such reply affidavit, such counter affidavit may be filed by the next day. Now give a date after 4 weeks.
Court may.
You have to do it today.
Almost, lordship.
Otherwise, we say that with respect to respondent number 5, the petition is infructuous. You argue only with 4, then ultimately you will not be able to argue.
Yes, lordship, we'll take it.
Because a private respondent here has to be noticed.
Yes, lord.
Court of May. Item 3.
As per the order dated 16/12/2025, we take a justice service upon the respondent number 7 to 11. So my friend,
Sir,
no,
what happened?
not sir, but my friend is appeared for a respondent also.
You are looking at them, you are not looking at us.
No,
Please answer.
no, because he is not. He is
They
informed.
have followed. You were looking here and there. What is the matter?
I'm sorry.
What is the matter?
Personally, it's a matter to the promotion to the.
No. Why has it come for orders?
Oh, orders for the service of notice upon the respondent number 7 to 11.
7 to 11. You have not served.
I have taken justice service upon the respondent order
You have taken dusty service means you have served them dusty.
to the respondent.
It could not serve.
Yes, they could not serve.
What do you say? What do you mean by taken service by dusty? You have obtained the permission to serve them dusty.
Yes,
Do you mean that?
yes.
So have you served them?
No,
Why?
because they have refused to take the notice.
That they have, it will be
Yes.
service of notice.
Yes, I have filed an additional affidavit. It is on page 209.
No, he says refuse. No, he says refuse.
7, he did not respond to your phone call.
Yes,
And others you could not serve because it is your statement because that they had already. they
They are
are
retired from service.
Isn't it?
yes,
Yes.
yes, 7 and
Look
9.
at the statement that you are making.
Para 4.
You ask my brother just to explain what you actually meant. Why?
No, Rosiel. Because respondent 7
Paper
and
publication you want? All of you are.
No, Lordship, for respondent number 7, 8, and 9, Lordship, we get an instruction to file wakalatnama.
Therefore, you are
Immediate, yes,
Forget
my
about the instruction.
Yeah.
You are appearing for 7, 8 and 9.
7, 8, 9, 7, 8, 9,
I am put all in the respondent 1 to 6. No.
1 to 6.
1 to.
And who, 10 and 11?
they have retired and we have to know
Doesn't matter, but you have to serve them. Paper publication. Since response number 1 to 9 have already appeared through respective counsel. The pleading with respect to them is complete. The already appeared. No further step is required to be taken. The lead counsel for the petitioner submits that respondent number 10 and 11 could not be served even thusly for the reason of their having retired and moved to a different location. Stop. Under such circumstances, a prayer is made for substituted service of notice to paper publication over the applicant newspapers and the date is one, so take it from him.
Court may. Item 4.
May I please? While last order dated 12/25, the opponents are applicants are directed to take paper publication, my lord. The paper publication has been made, in this regard, I have filed an affidavit, my lord.
We'll wait for one more occasion for the respondent to respond. Let's see. He might have received, he would not know. Right?
Two papers they have already published.
As like, though paper publication of notice has been done in respect of sole respondent, but nobody has appeared on his behalf to contest this application, seeking condemnation or delay of 160 days, giving one more opportunity to the respondent to respond to this application if deemed necessary. The matter is adjourned. We give 2 weeks, and that is the date when we decide on merits.
22nd April.
Merits with respect to delay.
Item 5.
Notice has not been received. Not unserved notice has been received. Awaiting clear report regarding service of notice on the newly added response number 1.1 to 1.5. The matter is adjourned to Swansea.
Hello, may I make a small prayer, my lord?
Yes.
May I make a prayer that the notices now effectively served, because on 2 occasions we have taken notice by my lord speed post as well as registered post as well as by the my lord regular postman, and I am under instruction, my lord, I have been intimated that they, because the actual petitioner had now expired. So the family members, they are not interested and they do not accept the notices, my lord. If your lordship kindly permits me, my lord, bear residence of Benares.
You file an affidavit that they are not interested and therefore they are not coming, we'll ignore them.
My lord.
File an affidavit. But otherwise, we have given a time.
My lord.
Awaiting the clear instruction. With respect. In the meantime, you file an affidavit. If you had filed the affidavit today, you would have straight away gone. And that affidavit perhaps would be a faulty affidavit. How can you assess the mindset of others?
No, my lord,
Anyway,
basically it is between brothers. So, my lord.
All right.
If your lordship kindly permits me to bring that affidavit and record within 7 days, my lord, I'll try to bring the record, my lord.
Sir,
My lord.
generally registry goes to the on next day, they will that report,
My lord.
postal report, then they will give a notice on the next, the report that it is served or not.
We are ready to accept an affidavit from your side also.
My
that
lord,
they are not-
my lord, kindly, if your lordship give me a liberty to bring it on record within 7 days, I'll bring it on record.
What liberty? You can go to the registry and ask.
Yes.
You don't need a judicial order for that, do you?
But sometimes they don't accept, my lord, that is the problem, my lord.
All right.
I'm okay.
22nd April. Item 7.
Muqaddama filed by response number 123. Only 3 responses.
But if I am appearing for respondent number 1 to 3, we have to file objection, it is a petition for delay also. Because
You
1,000.
will file or you have filed?
I have to file also.
Mr. So-and-so, and an advocate who appears for response number 1 to 3 submits that he shall be responding to this application seeking condemnation of delay. Let the affidavit as prayed for be filed positively on or before the next date with a copy served in advance to the learned counsel for the applicant. Re-notify on 3 weeks.
Obliged.
3 weeks.
Obliged.
23rd April.
3 weeks.
Item 8.
Application for condemnation.
Awaiting the report of service. Report regarding service of notice on the respondents, the matter is adjourned for 2 weeks.
It should come for the first time, my lord. Notice is required to be issued.
Oh, first time. No. Read the order 7/1/2026.
Notice-
Perhaps the order was passed behind your back.
Maybe, my. Oblige me. Oblige me.
Mr. Sharma, you have taken steps also, my brother informs me.
2030.
My lord,
How come this lack of communication?
perhaps, my lord, my other friends, my lord, that has.
All right. All
I'm
right.
sorry, my lord.
Item number 9.
Your Honor, please. Please, my lord.
Now, my lord, the request which we were making earlier
Yes.
morning was that, my lord, there is a counter to the affidavit which is filed by them. So now basically the affidavit, the counter which I'm intending to file and get it on record so that the arguments can be taken place and proper gist of this matter can be put before this honorable court is that, my lord, we'll serve it. And if it can be heard today, that's my request.
That depends on how fast uptake Sumitra has. If she agrees.
My lord, that is true, my lord. My lord, I bow down
We
to.
would be under an obligation to give her time if she says that no, I'll take some time to go through it and.
My lords, I totally bow down.
And
But
she
my
takes
lords,
instructions also.
but then, my lord, there is a small request to that. My lords, just take 1 minute. My lords, those documents which I'm relying upon in that counter affidavits are basically the contents and the annexures
That's
and
your
the documents
that's-
which were relied by
Mr.
them.
Counsel, that's your understanding.
Yes, ma'am.
It may not be accepted by the council for the other side.
Then, my lords, we have the ladies' version. What ladies have to say, my lords?
I can see that she's sitting quietly thinking that the court is making all orders on her behalf. Can you read and update yourself and argue this case? Today we will give him a hearing since he is a counsel from outside.
Well, if there are.
We are not insisting, we are only asking for your consent.
I'll have to take up instructions from you.
All right. So we adjourn the matter for the next date, 7 o'clock today.
I'll do that
It shall
today
be
itself,
done.
my lords.
Where are you coming from?
My lords, I'm coming from Delhi High Court. My lords, I have appeared before my lords many times before in the year 2017, 2016. So once I heard it was before my lords, firstly, my lords, how are you, my lords? This is
Very good. Good to see you.
please, my lords.
We are not saying anything. We are only adjourning the matter with the understanding that whatever affidavit you have filed in the registry, a copy is served to her.
I'll do that right now.
There would be no requirement of filing reply to reply to reply. Correct.
But then it will be a never-ending process.
Never ending process. That will be the end of it.
Yes, my lords.
Correct. So not for replying, but for taking instructions on the affidavit which is filed. And next date, we must hear it.
Yes.
Correct? So re-notify on at the request of MS so-and-so, let this matter come up for consideration in consideration on so-and-so. When do you want?
My lords, will it be this month or the next month, my lords? As per the roster of this court?
Next.
If it's next month, then make it 27th of April.
Yeah. 27th of April. You get plenty of breathing space, MS Sumitra.
My lords.
Please, grateful you.
Only thing, my lords, they say that they have filed without serving a copy on me.
I'll do that today itself, ma'am. Without any hassle, without any hassle.
Filing, my lord.
That doesn't
process,
matter.
my lord, yeah.
It takes time.
All your complaints should be directed towards Mr. Mr. Chamaria. Spare the advocates from outside. You direct your anger to the local council.
That burden is on my learned friend, my lord.
All right, yes.
Grateful, ma'am.
Supplementary list for orders, item 36.
Yes.
Yes.
What review do you want?
Now, my lord, lordship
Let us
kindly,
wait for a minute. Let's see.
please, my lord, 100.
Just a minute. Just a minute. Yes, where do you find the fault line? You're for whom?
We are for the respondent number 1 and 2 in the data. Now our service has been provincialized in the year 2015 itself. It is not that our service is to be provincialized.
See. Whenever it has been done, but under 2017 Act, which under or but by virtue of the neo judgment, it was to be done in terms of 2017. So even if it is done in 2011, the 2017 Act itself provides that all past acts again be revisited as the 2017. So that's why it is given in 2007.
With all the reliefs coming your way, you're coming for review.
Now, Lordship kindly see the judgment passed by the Honorable Single Judge. Lordship kindly see for a moment, Lord. Page 135, Lord.
Technically, that was incorrect. So, right.
Page 135.
Yes.
Property part, my lord. Page 145. Last paragraph, Lordship kindly see for a moment, Lord. By referring to page 37, Mr. So-and-so, learned counsel for the petitioner stated that the school was already provincialized, but it is only the salaries which are not being paid to the petitioners. If that be so, the school is otherwise be provincialized as held by herein above. Consequence thereof.
That benefit flows to you, Mr. Counsel. Try and understand what Justice Chaudhary just told you and which is there in the order.
Yes.
Look at this. Whether it is 2011 or 2017, there is an enabling provision under the later act also.
Yes.
So therefore, all your services shall be counted for the purposes of computation of salary. What are you saying? All relieves your way and you are still not happy. No,
my lord, this is not, my lord, the correct position of the law, my lord. Lordship kindly see, my lord, section 24 of the Act, 17 Act.
Mr. Mandala, provincialized after school.
Yeah.
This was taken. You want this judgment to be a state. We will hear your review. Notice you say, and we stay the operation of the order.
No, my lord, for a moment, my lord. Section 24 of the Act, my lord.
Sometimes
Act says whose services have been provincialized, they shall not be disturbed.
We have taken your objection into account. We issue notice to Mr. Khatnia, let him respond, and this review till the time we stay the operation of the order. Good.
But we are not seeking the stay of the order.
We can't do otherwise. What is this? I mean, I don't understand what grieves you. What is your grievance point? Where is the fault line? You show us the law, we will decide.
Now, our grievance, our service has been already provincialized.
So therefore,
we are entitled the benefits of.
We admit this review petition, we will hear it.
Apply, sir.
And Smith. Give a date sometimes in May. Respond, Mr.
11 May. Daily list for admission, item 13.
May I please, Madam?
Yes.
The actual counsel, Mr. J.K. Gogoi is not there. On behalf of him, I come.
You want an adjournment or you are seeking permission to argue the case?
I'll just make a small submission.
Yes.
Since it's regarding the Tiwa Autonomic Council rampant corruptions which have taken place. So that is why we have filed this PL. So on behalf of J.C. Gogoi, I just want to make a submission, my lord, if you permit me.
Yeah, please go ahead. The question is that our initial impression is that it is too broad based for any judicial order in a PIL petition. So I think you better exercise your option of asking the lawyer who is responsible to argue this case to argue. It is too broad based. India is facing corruption. Let's pass an order. Something like that. Correct. So either you argue and have the case dismissed or you take some time because it's too broad based. It's an open-ended kind of an allegation. There is no specificity. And these matters cannot be handled in a PIL. You have to find out, you have to tell us You have to give us specific indices. Corruption. Corruption is such a big term. Corruption, yes. Ills of corruption are everywhere.
Then
how do we pass a judicial order to take money? No, just a minute. Now, there's yet another aspect to this. Now, what has happened after the extension of the term of 6 months? Has it again been extended of the Autonomous Council?
not yet.
So have you questioned that?
No, our humble,
Have you questioned that? We are asking you.
I'm sorry, my lord. I'm not aware of that. Because it is, the petition has been drafted by the J.C. Gogoi. I was simply told.
Therefore, better option.
Better give
you are
us.
holding the brief from Mr. Gogoi.
Then
Let Mr.
my
Gogoi
lord,
argue the
the
case.
dead may be given.
He suggested to you in the beginning because it's the petition is not drafted happily. We do not know.
My lord.
All right, as prayed for on behalf of the petitioner, for the absence of the learned counsel who is to address this court. The matter is adjourned to give date after 4 weeks.
Deeply 6 May.
Are you questioning the extension of the life of the council?
We are coming for the corruption only. They have misappropriated and siphoned the entire development fund, my lord. That is the issue here, the PIL.
Now, how many months left for that extended period to expire?
Already 2 months over, another 4 months is there. What we want is that, my lord.
You would be required to answer whether you can do that. Whether you can do that.
No, only we are regarding the corruption part.
He unnecessarily talks about corruption.
Yes.
He should talk about that is very secondary.
But
He says that corruption, and that is why
misappropriation of the
just a minute, Mr. Just you were about to have this case dismissed. Now please wait for the court to respond. Now he wants to say that corruption is there, but this corruption appears to have been institutionalized by extending the term and not passing a fresh order.
My lord will come to page 34 of the.
Please respond to this petition. Let counter affidavit in the matter be filed positively by Mr. So-and-so appearing for respond number so-and-so. Give a date of 1.5 months. That is 6 months.
6-5. Deeply. Item 14.
Yeah, Mr. Lordship, my lord. This petitioner is 24 or 5 years in rendering master role, then their name is also recommended. But when it is not done, the petition that was not dealt with. Rather, a impugn order is passed that the transfer to the ULB, municipal, without pay protection.
Now, getting part of tail of what you're saying. We do not know about the facts of this case. You have to tell us.
My lord,
don't accept this habit as of argument. Because many a times we the outreach of the bench is that before you speak, we start speaking. That is the problem. Now, many a times we would wait, we would want the lawyers to speak. No, don't think that we know all the facts of this case. You'll have to start, you'll have to argue. What is the matter? What is the, don't think that we are all prepared with all the files. Yes, now what is this?
My lord, that's my facts is that these petitioners, they are the master roll workers. 1990, they are appointed.
1919, they were appointed.
Sorry, sir, my lord, I'm sorry. 2000.
They would not have been alive if they were appointed.
My lord, I'm sorry.
19?
Not 19.
आप आराम से फाइल देखकर बहस करिए. Yes. Don't bank on your memory.
My lord, 2000 onwards, they are working. So they are 24 and 5 years. So
just a minute. Just give us a minute. Urban water supply and sewerage board schemes. So urban local body. 2022, the notification of transfer to be challenged. Yes, Mr. Counsel, how do you ascertain the order passed by the learned civil judge? Now, we are in conformity with the impression of the learned civil judge that it was only a change of the employer. That question, that notification whereby the urban local bodies were handed over, men and machines, from the sewerage board, correct?
Yes,
So that challenge could not be sustained, correct? We also think that way. It can always change hands. But then if you were doubting the fiscal capacity of the boards to pay you salary regularly, the court has taken notice of that. And the court has directed that it should be released to you. So far, so good. But here, Uma Devi, with all paragraph 47 and 56 read together in a positive manner also, it comes against you. Because you were a scheme-based hire. Scheme-based. Right. True it is that you have worked for more than 20 years, most of you. But then the government has to take a call. We can't pass a mandamus. Notwithstanding the judgment in Jago, we can't issue a mandamus because they still need you. Let's see what the state has to say. Yes, who appears for the state?
My lord, we are appearing. But I'm sorry, my lord. Unfortunately, that file has not received in the office, my lord.
Unfortunately, what has happened?
That file, my lord, we have not received in the court, my lord. We have to verify whether.
Are you tomorrow? Tomorrow, how many matters we expect? Are you tomorrow?
My lord.
Bring your file.
My lord.
Let's see what can be done.
My lord.
I understood, my lord, the pay protection, without pay protection, they are in danger because ULBs are financial.
Protection is a different concept, Mr. Counsel. Please don't confuse and conflate.
They are given their basic pay, my lord. Although they are temporary, they are enjoying that. Now, when they are transferred, moment they are transferred to.
Don't dilute your case. You are on a stronger footing. आप वो कहेंगे तो फिर ये direction है. This is the law. They would have the base level minimum pay of the workers who are of the same status. So I'm sure you're not asking for that.
Yes, I'm asking because ULB what says that.
So where is the dispute then? Then perhaps you don't want regularization in terms of Jago. If you don't want, it's very easy for us to explain just now without the counter.
Regularization also we ask that is the question. All right, my lord, they have been responding.
Please don't settle for something very paltry.
My lord.
At least struggle, at least fight out. You may have a little chance, but then let us apply our minds to it.
My lord.
Otherwise, the learned single judge has been very, very careful in framing his order. Very, very careful. And he has given you everything that you deserve. But still, let us show some more generosity and see what can be done. What it is done. Please, I care for the state submits that the file, that the authority, you go, let the facility take it. The case at hand arises out of a long-standing grievance of the petitioners who are employed, of the appellants who are employed under Assam Urban Water Supply and Sewerage Board, hereinafter called the board, a state autonomous body under the Housing and Urban Affairs Department, responsible for urban water and sewerage schemes. They worked on muster roll since 1990s. But after 20 odd years, they were converted to work charge employees entrusted with identical duties performed by regular staff, such as maintenance of water supply and sewerage infrastructure. They also received similar pay allowances and increments. And their service book also was maintained. Despite this parity, their services were not regularized. Leaving them vulnerable, especially as most of the appellants approach retirement age or have crossed the recruitment age limits. In the meantime, next pattern. In the meantime, the government took a decision on 21st of June 2022. Issued a notification on 21st of June 2022, transferring the ongoing schemes under the board to urban local bodies like municipal boards, urban local body like municipal board, urban local body that is municipal board. This handover was smooth, but the appellants had feared that their salaries would be delayed because of the financial constraints of the urban local body. And they would also lose out on certain benefits under the board. There would be job insecurity. The main concern was that with this handover and the background of such urban local bodies struggling for revenue, salaries would not be paid to them. There was a further concern of the appellant that some of similarly situated persons were selectively regularized way back in the year 2006, which the appellants claim is a hostile discrimination. The contention of the appellants was dismissed by the learned single judge, that the transfer of men and machine under a scheme of the board to an urban local body was only a change of the employer without prejudice, as this change also would not undermine the perennial nature of the earlier water/sewerage scheme. So far as the prayer for regularization is concerned, the learned single judge was of the view that the judgment of the Supreme Court in Uma Devi to put a detail in last state of Karnataka, so I don't remember. Uma Devi would apply proprio vigo for the reason of the appointment of the petitioner, for the reason of no appointment of the appellants against sanctioned posts. Not with, however, while observing this, the learned single judge directed for immediate release of pending salary, and also cautioned that there should be timely future payments, even if it were required via the state grants in aid provisions. The land council for the appellants therefore submits that while referring to the judgment of Uma Devi, the learned single judge, judgment of the Supreme Court in Uma Devi, the learned single judge did not favorably consider the fact that the appellants had been working and discharging their functions as regular staff, where they were continuously required because these schemes are of a perennial nature. To stop under such circumstances, with the requirement of such working hand with the urban local body, or for that matter, any state autonomous body, the state as an employer cannot give a blind eye to the requirement of regularization. Let the state respond to the aforenoted ground raised in this appeal by filing a detailed affidavit. The affidavit in question must be filed on or before the next date. You are settling for what? Which you have already got, Mr. Kams. We should not have labored so much. We should have accepted your plea.
28-4.
May.
11 May. Item 15.
We are working on it. Think about it.
1st of June. 1/6.
Till next.
Item 15.
My lord?
Yes.
Subsequent to the annexure B, my lord, in the IA.
You have straight away come to an lecture. It has
Yes,
come for the first time.
Yes, my lord.
What is the matter about?
My lord, the matter is pertaining to a judgment and order, my lord, dated 4/11.
We are making it again very clear to the elected advocate.
My lord.
Our outreach should not make you feel that we know everything.
My lord, I apologize.
You must argue.
I apologize, my lord.
Afresh.
In fact, my lord, what has
I've seen this practice growing over past 7 months, that you straight away come to some paragraph or
No,
some
true, my
part
lord.
of the order.
My
You
lord.
might not know the background facts.
True, my lord. True. I
Please
apologize,
argue.
my lord. My lord.
As you argue before any other bench.
My lord. My lord, my issue here today, my lord, is prior to arguing the matter, there have been subsequent events which have transpired after the annexure B, which I've just pointed out.
What is the event which has
My lord, what has happened is a disciplinary proceeding, my lord.
Disciplinary proceeding against whom?
Against the appellant, my lord.
Who is the appellant?
The appellant is
इस तरह के क्या
the appellant is a registrar, my lord, under suspension of the Gauhati University.
Suspension of?
Under suspension of the Gauhati University. The appellant is a registrar, my lord.
Registrar.
There was a departmental inquiry which was conducted against the appellant, my lord, and there were findings of the inquiry report, which pertain to his dismissal
Thereafter, my lord, without affording an opportunity to the appellant to furnish his statement or to furnish his reply against the inquiry report, the disciplinary authority, which is the Executive Council of the Gauhati University, my lord, had already accepted the entire recommendation of dismissal of the appellant. Being aggrieved, my lord, we had approached this honorable court. This honorable court, my lord, had taken a threadbare perusal of the matter and had passed the impugned order, my lord, which your lordship will find at page 227. Now, the impugned order goes partly in our favor to the extent that the entire departmental proceeding to the stage of cross-examination of the prosecution witnesses by the appellant was remanded back. Now, we have filed this appeal to the extent that we seek before this honorable court, my lord, that the entire departmental proceeding should be remanded back to the issuance of the stage of show cause, thereby appointing a new inquiry officer.
All right.
The reason being, my lord, the entire departmental proceeding in our humble submission, my lord, in the writ petition as was also prayed and before this honorable court, my lord, is vitiated by elements of bias. That aspect has been captured, my lord, in the impugned order dated 4/11/2025, my lord. My lord, the order starts at page 227. 227, my lord. 227.
Yes.
My lord, has seen that, my lord. Then, my lord, your lordship will kindly come to page 229, my lord. These are the submissions of the appellant's counsel before the learned single judge. At page
stage did you approach the court?
My lord,
Only when you were refused to be cross-examined, only
No.
when you were refused the opportunity to cross-examine.
my lord. No, we had approached this honorable court when, my lord, will kindly come to page 97 because then inquiry, my lord.
Speak and then show.
The inquiry officer had prepared his inquiry report.
Right.
And the inquiry officer had gone beyond the mandate of Rule 9 and suggested my dismissal from service, which he could not have done that, my lord.
No. See,
One.
the inquiry report was there before the disciplinary authority,
Yes,
right?
my lord.
Inquiry report had suggested that you should be dismissed.
My lord.
That is something which is not mandated under the rule. They were just supposed to say whether the grounds of
Fine.
I mean, the charges were made out or not. That's right. So this could be kept at bay. These are, these are ways in which people speak, people write. It could be faulty. But then was it accepted by the disciplinary authority?
Yes, madam.
What? You were dismissed from service?
No. The fact is, when the inquiry report was furnished on me to prepare my reply to the inquiry report, the inquiry report was stated to have already been accepted by the disciplinary by the executive council. My lord.
Many a times it happens that the service, the disciplinary authority would again, in a faulty way, give an opportunity of second show cause, but not exactly the second show cause, about the explanation of the delinquent, the expression of the explanation of the proceeding, whether it should be accepted and whether he would like his own way. Because that's nothing. So it was quashed.
It was quashed
For the reason of this.
For the reason of this,
accepted it.
and
then issued.
No, and there are other surrounding
Therefore,
factors
the primary ground was that you were not afforded an opportunity of cross-examining the witnesses.
that the
Right.
conclusion was
So
on
therefore, why I'm leading you to this,
My lord.
this is the way we catechize. This is the way we elicit answers.
My lord.
Because the answers are there in the question. So therefore, the vulnerability surfaced at the stage when you were refused cross-examination, the opportunity of cross-examination.
My lord.
Right. From there only the matter has been remanded. So far, so good. That is what ECI versus Karunakar tells us.
And Mohammed Ramzan also, my lord.
Mohammed Ramzan comes later. Karunakar is the last word.
Yes, madam. Madam, we have cited those judgments in our written submissions.
And
also.
we have also passed very many judgments authored by me that there should not, there is nothing called general remand. That means nothing. That would let the other side, the employer, fill up the lacuna. No. Where the vulnerability surfaces, that is the stage from where the remand should be made.
True, my lord. And in fact, to that extent, the impugned order, my lord, has been to our favor. There is no dispute to that.
But be happy.
No. In fact, what has happened, my lord, there are surrounding circumstances which will go on to indicate, my lord, that the disciplinary proceeding proceeded in a manner which was not conducive for an unbiased
No, where is that?
proceeding.
Where is that ground? Otherwise, we go for review. Why do we interfere? We are absolutely happy with this order.
My lord, your lordship, we kindly
You may not
complete-
be happy with this order, we are happy
No,
with this
because
order.
what is happening?
Where did you say that it should be quashed in limine? I mean, it should be finished, fresh. If, a new inquiry officer should be appointed because he has a bias. That would have been your main ground. Let's see your memo. Let's see your writ petition.
My lord, the petition starts at page 18.
Page
18, my lord.
Record.
The prayer portion, my lord, page 18 is where the writ petition starts, my lord. Page 18.
Yes.
The prayer portion starts at page 39.
Page 39.
Page 39, my lord. Should I permit it to be read?
Yes,
my
yes.
lord. A rate in the nature of certiorari shall not be issued, quashing / setting aside the entire departmental proceeding initiated against the petitioner, initiated pursuant to the memorandum of charges dated 23/10/2024, as well as all subsequent and consequential actions thereto, and or
Considered personal bias. Where have you talked about personal bias?
no, my lord. In fact, the reason that we have prayed for setting aside of the entire departmental proceeding
You have understood. You have understood our objection.
I do. In fact,
the question is this.
Yes, my lord.
Now you went to the court saying
My lord.
that the disciplinary authority has in principle accepted the report. Therefore, it is only a formality that I have been asked to respond.
My lord.
That ground, you have many judgments with conflicting stand, which says no. Thereafter, the decision would be seen how it has been formulated. So far, so good. But your grievance has been redressed. Now, whether it was accepted, it was not accepted, the major ground which attracted the attention of the London single judge was that you had pleaded for opportunity of cross-examining the witnesses that was refused.
That was
correct. So therefore, the vulnerability began there. Where is your statement? Where is your prayer that this inquiry officer is biased? See, if the judge would have said that, we would have set it aside. You can't do that. PK Dev is the judgment which starts. Fortunately, it is from your state. Correct. So therefore, you cannot pray for it unless you have raised the plea of personal bias. I don't think you have raised that plea ever.
Now, the entire aspect of personal bias, my lord, subject to also final determination. My lord.
Mr. Sharma, where have you raised that plea of personal bias?
The aspect of personal bias, my lord.
But can we infer it from your petition?
No, in fact, what has happened, my lord? The entire
you have understood our objection.
We have.
Please prepare on that and then let us.
In fact, my lord, we need a liberty, my lord, from this honorable court to also.
We are giving you the liberty because see this. You have been taken by surprise today. You have been taken by surprise today by the observations of the bench. We'll give you time. You prepare on this. Question is, we have a feeling that for the lack of opportunity, we are of the view, judges should not have any feeling. We are of the view, considered view, that with the lack of opportunity given to you to cross-examine the witness, this was a big vulnerability on face of it, and therefore the single judge was right in remanding it from that state. Correct? Right. Now, had the judge remanded it only for the purposes of saying that this report acceptance is bad, it would have been quashed totally. Correct. So it was basically for the reason of remedying that defect of you not having been provided with the opportunity of cross-examination. You bring out a third element, which was neither your case before the writ court, nor can you plead before the appellate court that the inquiry officer is bad. His opinion is biased. We don't want him. We want a separate. Where is that provision under Rule 9? Unless you raise personal bias. I mean, I don't think you are there. No, that's all the report. And therefore, you will find further cul-de-sac. You don't understand what cul-de-sac is. End of the road. Even if you ask for it, they'll say that, well, for Rule 9 says that no, separate inquiry officer. Why? Why there's no objection, no confidence on him without raising any specific plea? No personal bias, no plea. And in that case, this appeal, you can't raise this matter in appeal. Are we being too technical?
No, absolutely.
I'm asking you, are we being too technical in this?
No, I understood. In fact, what you That particular.
Mr. Sharma, please prepare. You have the capability of finding out some way. So let's see, we give you some time.
My lord.
Today, we are inclined to dismiss this.
Lordship will not do that today, my lord.
Therefore, we never take people by ambush.
I'm ungrateful. Ungrateful for this.
As great for the appellant, re-notify, so it's
21-4.
4 weeks.
4 weeks, my lord. I'm grateful.
Most of 21-4.
Withdraw this appeal, file another appeal. Go before the single judge again, or go before the single judge again. I think that's a better advisory. This cannot be questioned. We are absolutely sure. He has seen the vulnerability. He has hit there.
In fact, that aspect was not taken by us.
Take instructions, withdraw this appeal, file another petition, say that we could not say this, that this is bad. He's biased. It will not be permissible, so otherwise also you lose. Go for review.
I'm grateful, madam. I'm grateful.
No pleading. ना फंस गए आप रिव्यू भी नहीं कर सकते, pleading ही नहीं है, वो dismiss कर देगा order 47.
Trying on a very remote stretch to satisfy the honorable court.
Therefore, we say we use the expression cul-de-sac. There is end of road all sides.
In fact, the entire conclusion of the inquiry in our humble submission was indicative of the conduct of the authorities, my lord. That
never did you press for
that we missed.
Never did you pray. It's a very serious matter, no? Changing the inquiry officer by a judicial order, it requires specific pleadings with attendant circumstances and evidence. Otherwise, if a judge does it on his own, exercising the powers under Article 226, overall control, PK Dev comes into play. PK Dev is the judgment. PK Dev comes into play. 1970s judgment. All other judgments, follow suit. Correct? So, I think you have committed a harakiri. There is no way in which you can help your client resuscitate. Okay, let's see. Next.
Item 16.
May I please?
Yes.
So this writ appeal has been filed by the writ petitioners, some of the writ petitioners, against the eviction process which is being undertaken in the Pangla railway station for implementation of the Amrit Bharat station scheme. These writ appellants belongs to very low social economic structure.
Actually, railway station,
Yes.
railway station dwellers.
Yes.
Low economic status.
And they were functioning there by providing the amenities to the passengers which could not be provided by the railways when it was established way back in 1960s.
What is this Amrit Bharat scheme for? Providing
For
upgradation of the
railway station, my lord. And they were, for the last 50-60 years, they were providing the amenities to the passengers who comes and goes.
And what is the eviction notice? What does it say?
But eviction notice is about the cancellation of the land license agreements that were given to their predecessors, my lord, on the basis of which they were on that land, my lord. And their renewal fees
You
were.
question the cancellation of the license.
My lord, that is there, and
You have to be specific, no? Then only we hear you.
because
It's an
my
appeal.
yes, ma'am.
It's not a writ petition.
Yes, ma'am.
So we hear an appeal.
Yes.
So
Well, regarding the questioning the cancellation of the land license agreement, only thing remains is whether there is any rehabilitation.
no, that is something else.
Yes.
Let us first question it whether the government, whether the railways were entitled to cancel it.
Yes, ma'am.
One, if at all they are entitled to cancel it, would they be under an obligation to look for the rehabilitation plan because you were made to stay there for a long time?
Yes, madam.
Since times immemorial.
Yes.
If not so old, then at least 50-60 years.
Yes, madam.
Then you can't be thrown out because you're poor. State being a welfare.
Yes, welfare
state,
statement.
and the railways being a big employer.
Madam.
Correct.
And they were in a symbiotic relationship.
Later, first chicken or the egg, that dispute remains forever.
Yes, madam.
Chicken came up first or the egg came first, that is a dispute. Therefore, let us see what is the cancellation notice.
Madam.
You never know the railways. Railways has come with a plea that we have never given license.
Yes, madam.
Many a times they come with the same plea. Shows the cancellation.
The cancellation starts from page 84, my lord. termination of temporary occupation of land license agreement.
Let me just.
Lord, may I read, my lord?
Have to read because it's blurred.
My lord, two Sri so Provin Borough.
So clearer copy, Lordship will find.
My lord, there's other
86
copies.
and 87, Lordship.
Yeah, these are the bunch of termination notices. My lord, may I take up page 88, my lord, that is clear.
88 is very clear. Yes. No, 86 is clear. Read from 84.
Yes, ma'am. To so and so, termination of temporary occupation of land license agreement as per clause 20 of the agreement, plot number 22 at Kongla Station. In connection with the subject cited above, you are hereby informed that Railway Authority has decided to terminate the land license agreement with you for temporary occupation of the land at Kongla Station, land license plot number 92 as per master plan approved by the headquarter drawing number so and so as per clause number 20 of the land license agreement for purpose of development of Tongla Station under Government of India.
जो भी हो उससे मतलब नहीं है. Termination of land license agreement with you. Show us one copy of the land license agreement.
Yes, sir.
Purpose होगा कुछ भी.
My lord, may kindly turn to page 159, annex of 5. And there are type copies also starting from. My lord, may come to page number 119, my lord. That is the type copy of the land license agreement. And the clause 20, my lord, is at page 123. These land license agreements were renewed from time to time, my lord. At page 123, my lord, clause number 20, which they are trying to invoke now. May I read that, my lord? The government shall be entitled at any time to give notice to the licensee of its intention to resume possession of the land, subject to the provision herein. After contained, the license shall vacate the land, remove all materials and building belongings to the licensee, and restore the land to its original state within 30 days after the date of such notice. And the government shall not be responsible for any inconvenience, loss, or damage that may be caused or done to the license by reason of his having to vacate on such notice, provided always, and it is agreed that the government, upon giving notice to the licensee of its intention in that behalf, concurrently with the said notice of intention to resume possession, shall be at liberty to purchase from the licensee and take over all or any building erected on the land by licensee at fair value.
Whether there would be any obligation of the railways for rehabilitation, because you were not under distress. You took it on a license on a fee. And fee was not 2 rupees or 10 rupees or 500
Yes, well,
rupees.
it is
6,700 something.
Yes, ma'am.
Correct.
Yes,
So
ma'am.
this was for doing business.
Yes, ma'am.
Now you don't fall in that category where for evicting you or for transferring you or for removing you, there has to be a plan.
Yes, ma'am.
This is government property. Government says that we are giving
is
you
true,
notice. Now you please vacate. You have earned your livelihood for so many years. What do we do with this? गलती कहाँ है हमारी property है
That my lord, my humble
notice दिया कि नहीं दिया? Notice दिया.
My lord, the notices were in the name of some other person. We were staying there on basis of those. It was not. Yes, so they should have.
Could not have been sublet. That's one of the grounds.
Yes, but then we are unauthorized occupants, and they have to proceed under the public premises.
You have said it. You have said it. क्या करेंगे इसमें कुछ नहीं है. Judge was right. आप बोलिए कोई रास्ता दिखाइए तो हम करें.
My lord, as per the last decision
because you people were paying that rent, you don't fall in that category where it could be said that you are flood hit, your weather hit, you're this, you're that, and the responsibility. Now, welfare state, we can't stretch the state for such additional plans for settlement, for life, for livelihood.
Well, at least they may decide on these 9 appellants, my lord. Only 9 of them has approached.
Five, right?
Others have not approached. Malad.
Five special permissions. Huh?
They have to open a pendulum.
No, no, open, but they must show something to us. आप पैसे दे रहे थे.
Yes.
You were paying that license.
Renewal fee.
You're not destitute.
Yeah.
And then you would not have been paying only for that. You would have constructed a shop. You would
Yes,
have
we have.
earned out of the providing
Some of them-
services to the passengers.
Yes.
And a 5 rupee egg or a 10 rupee a boiled egg, you would have charged 25 rupees because these are remote stations.
Including clothing, you know.
Who certifies that you have been very,
They've
very
survived.
honest in your dealing?
They have lost their livelihood, my lord. That is.
You have, but then that was contingent.
And they were on a symbiotic relationship all these years, my lord, with the railways. Now this railway is cutting off that. So at least a rehabilitation package, if
There
they
was
can,
not symbiotic. Not symbiotic.
because the railways are supposed to provide all the amenities.
That is what they have.
Now
Census.
they were providing those.
I think you have converted the commercial area to residential.
Some of them have half commercial, half residential. Well, they're built also.
We are not dealing with that because there is no charge in that notice.
It's fine. And they're supposed to be a temporary occupation as per the license.
Yeah. जब वो बनाएंगे, then they will let it out. They will not
Yes,
have their own caterer.
Yes. At least that preference may be given by.
No, we will not say that. You have not asked for it. We will not say. That calls for a separate petition before a single judge, not in a plea. Taken. You have heard Mr. M. Patani. That is for the appellant. And Mr. R.K. Chaudhary, Deputy Solicitor General. Have for 2 and 4, Lordship. For response number 2 and 4. 2 and 4, Lordship. 4. PC. Dr. Shari. For response number 1, Mr. Bishan Vasari. Please cite here. Learned advocates have appeared for response number 1 and 3. The appellants claim to have been operating petty commercial activities such as shops catering to railway passengers on the land belonging to Northeast Frontier Railways near Tangla. Where is Tangla?
It's Udalguri district, my lord.
Borderline.
BTC.
Under Tangla railway station for approximately 5 decades. The appellants or their predecessors were granted temporary land license agreements by the railways for commercial use of the land, requiring payment of license/renewal fee. Over time, some licenses remained in the name of the predecessors, but the successors, some of whom are the appellants, paid fee and also sought transfers, leading to disputes over their legal status. However, later, in the year 2024, the railways decided to upgrade the railway platforms and modernize the same to provide better passenger amenities. under the Amrit Bharat Station Scheme, a Government of India initiative to modernize railway stations as referred to above, a decision was taken to invoke clause 20 of the license agreements of the appellants in cancelling such agreements with a notice to the licensees and ultimately resume the possession without any liability for losses, for the reason that under such license, the occupation was explicitly temporary and for commercial and not residential purposes. And not for residential purposes. Accordingly, the agreements of the appellants were cancelled and they were asked to vacate. Such termination of temporary license to occupy the land was questioned by the appellant before the civil courts by filing title suit and miscellaneous applications. They succeeded in getting temporary injunction, which ultimately stood vacated. It was only thereafter that the appellants preferred a writ petition before this court, seeking to quash the notice received by them and prevent the authorities from evicting them without due process under the Public Premises Eviction of Unauthorized Occupants Close Act 1971. Alternatively, it was put that the appellants and similarly situated persons be provided with rehabilitation or alternative accommodation, as such termination of license had led to abrupt loss of livelihood, long possession, and resultant socio-economic hardships. The learned single judge, by the impugned judgment, found that the appellants were holders of temporary commercial use land. They could not have been termed as unauthorized occupants under the Public Premises Eviction of Unauthorized Occupants Act 1971. For the process ingrained in the aforenoted act to be applicable in case of the respondents, in case of the appellants. In fact, the possession of the land of the appellants was purely temporary, controlled by the agreement which provided that the railways could resume the such possession whenever it wanted after giving 30 days notice to such licenses / settlings. The railways have taken the decision of resume such land for the purposes of giving effect to a Government of India initiative of Amrit Bharat Station, modernizing the services at railway station and making it more passenger friendly with good access, landscaping, etc. all the appellants were noticed and have been asked to vacate, which they are under an obligation to. The rehabilitation measures could have been thought of by the railways, but it cannot be directed for in the present proceedings for the reason of there being no evidence of the appellants being destitute or flood hit or landless. All that we can say is that in case such railway station, in case there is a modernization of railway station with any kiosks for passenger facilities, come on. In the event of the appellants applying for lease or license for running such kiosks, they ought to be considered. But this would purely depend upon the scheme of the railways in that regard. Finding no fault with the judgment of due in the present petition, we discussed this.
Much obliged.
That's the maximum which we have. We'll get a provide. We reassemble after 10 minutes. Has the matter been decided?
My lord, my lord, similar is fixed, my lord, on 26th of this month, my lord. 26th.
The associations had such have come, but then we are a standalone garden, we are not part of the association.
Doesn't matter. Let this issue would be decided.
Same.
Now, let me tell you, there was an occasion for me to meet army officers. They were so upset. They were so upset by, I said, but this is disability pension. This is.
This is land ceiling, my lord.
Sorry. This land ceiling, we have issued notice.
Yes, my lord.
And we have formulated issues also.
Yes.
When is the first?
My lord, that is fixed, my lord, on 26th of March. 26th of March, and then.
You have the copy of the order?
Yes, my lord. Yes.
This is item number?
18.
18 March.
I thought it was ceiling on level. Yes. We have formulated the issues, no?
My lord.
Noto, Holohon and Devraj. The issues have been formulated. We'll hear it together. Again, let petition be listed along with WPC number 501 of 2026, slated to be listed for further arguments on 26th of March 2026. We are keeping this order in the record.
Absolutely, my lord. Absolutely. And first.
Item 19.
Now, the observation which I made earlier was for this case, the disability pension.
In fact, Malad, here the not along with the tomorrow's matter, Malad, because here issue is Malad involving the broadbanding effect is given, Malad. Yolos other matter, Malad. Here the matter is fixed on 29 of April. This matter. Initially, of course, last order, last month's last part was only. This is the initial order, whereby stay has been given by the Yolos another bench, Malad. This matter is fixed on 29 of April, Malad.
Without discussing the merits, I don't understand.
Well, in fact, Malad, you also can
issue notice. Then we'll see.
Well, in fact, Malad,
when this matter is fixed.
Petition, the learned tribunal after 24 years, Malad, entertained the OA, Malad. Malad, without Malad. After 24 years, they approach, Malad. Now, our case is before the tribunal as well as before your lawsuits, Malad, that initially the Petitioners found 30% disability,
Just-
but at the time of.
Please hold on for a minute.
Paragraph 3.
1 second, sir. We read it
No.
to our own eyes. When this respondent was discharged in 1996.
1996.
से पहले सवाल पूछेंगे, सवाल सुनेंगे तब ना respond करेंगे. When he was discharged in 1996, was that a normal discharge or invalidation? Invalid discharge.
Initially, he found 30% disability.
Sir, should be there yes or no?
Yes, Malad.
You are asking for a stay of the order passed by the tribunal. Answer this in yes. In 1996, when he was discharged, was that a normal discharge? Yes. Okay. Now, what was the opinion of the release medical board at the time of discharge?
30% disability.
30%.
Subsequently.
No. When we are asking questions, answer the questions. If I'm not asking questions, argue the whole. Now, this you show us where this says, does it say that it was aggravated by military service?
It says that it was aggravated by the military service.
By 30%.
30%.
What is this meaning of 2 years?
For 2 years means his disease is found such a way that it will be cured. Accordingly, at the time of decision by the PCDA Allahabad, it is found that his disability is no longer there and it is less than 20%. 11 to 14%.
I'm on a different thing. You must understand where the court is going. You must understand before you ask for. If you don't press for a stay, we just issue notice. If you press for a stay, then we specifically reject that prayer. Therefore, you'll have to make out a case. Now, in this case, the opinion of the release medical board was rejected. It was not considered to be a disability aggravated by military service. Is that correct? When? When did that happen?
Annexer.
Prepared nahi hai, Mr. Goswami.
I am prepared, Annexer 3.
Give
to
us
the
the
affidavit
date.
opposition, page,
Give us the date.
page 121, date.
I'm asking for the date.
Date is 29.
When was that?
27/3/1997,
I don't think so. The date at the company 27/3/1997. All right. Was that communicated to the respondent?
It was communicated and subsequently Annexer 4. Later dated 29 April 1997.
Just a minute. The assessed percentage was 20%.
Less than 20%.
20%. Okay?
Even assessed from 11 to 14%.
Again, without being aggravated by military service? And was it also for a limited period of 2 years? Could not have been.
It is found for the period, it was written over at 27/3, 1/5/1996 to 24/4/2006.
And then when did he represent again?
It was immediately communicated on 20.
When did he represent again?
After 24 years,
After 24 years?
He was asked to file an appeal within 6 months, which he failed. Annexer 4 is the letter that was communicated to him.
All right. This is a ground for stay.
Highly blessed.
We have heard Mr. Goswami learned
Central government
for the Union of India and others, / petitioners. This petition is directed against the order dated 15/5/2023, passed by the Armed Forces Tribunal, Regional Branch Gauhati, in OA number 18 of 2021. Next, the respondent, the sole respondent, a former army personnel, was discharged on completion of his service tenure after 24 years, under the army rules, which was a normal discharge on completion of term of engagement and not by way of invalidation of service on medical grounds. However, at the time of his discharge, a release medical board opined that he had developed a disability by 30% for 2 years, which stood aggravated because of military service. Such opinion was not accepted. Which is the authority which accepts or rejects it?
PCDA pension Allahabad मतलब
PCDA का मतलब क्या होता है?
मतलब pension department मतलब of the army मतलब.
Give us the full form. We don't use acronyms in the first instance. We use acronyms in the second instance. So first time we say, which is this body, and then second time we have to refer it, we'll refer the acronym. You will do that. क्या लिखा है? By बॉडी का नाम बताएंगे. Allahabad. And the respondent was assessed to be having 20% disability, which was later revised to 11 to 14% after consultation with a medical advisor. By order dated 27/3/1997, which was communicated to the respondent on 29/4/1997. The contention of Mr. Goswami is that the respondent was made to understand that he could appeal against such decision of the authority to be named by Mr. Goswami within 6 months, but the respondent chose not to. So after about 24 years, the respondent appears to have filed an RTI application on 23/2021 seeking medical documents which were relied upon by so-and-so body. You have not been able to find out, mister. I'm finding it difficult. You do the acronym also.
PCDA, I'll give.
अरे अभी के लिए बोलिए ना. My sentence is not getting completed. PCDA, बोलिए.
Principal Commissioner of Defense Account.
Principal Commissioner of Defense Accounts, bracket में pension.
Principal Controller of Defense.
Mr. Chanda, you seem to be an expert in tribunal matters. Yeah, what is it?
Principal Controller of Defense Account.
Principal Controller of Defense Accounts, bracket pension. क्या लिखा है हमने? अभी क्या बोला? 23, these three, seeking medical documents by PCDAP. Thereafter, he approached the Armed Forces Tribunal by preferring OA number 18 of 2021, along with MA number 12 of 2021 for condonation of delay. Two, challenging the rejection letter of 1997 and prayed for grant of disability element of 50% by rounding off or perhaps broadbanding the release medical board's 30% assessment from the date of discharge. Stop. Mr. Goswami grieves, paragraph. Mr. Goswami grieves that this order impugned. No, actually, Mr. Goswami grieves that the tribunal allowed the prayer of the respondent and directed for grant of disability element at 30% as per the release medical board assessment, comma, rounding it off to 50% for 2 years from discharge, from the date of discharge. The order was to be implemented within 3 months of the passing of such order, with 6% interest per annum on delay. Surprisingly, the tribunal also rejected the Ministry of Defense's prayer for leave to appeal. For leave to appeal. The order impugned is stated to be erroneous, arbitrary, and in excess of jurisdiction by wrongly applying the judgment of the Supreme Court in Dharmeer Singh versus Union of India, 2013, 7 SCC 316, which decision actually deals with attributability / aggravation presumptions and disability pension entitlements. Stop. The issue before the tribunal in this case was different, namely whether such decision of the release medical board could be questioned after 24 years. Let notice be issued to the respondent on steps being taken by the petitioner, bracket में S, petitioners, within a period of 2 weeks, returnable on, give a date in June. Till such time, the order passed by the tribunal shall remain in abeyance. You have to make a Goswami, you have to make a case for, otherwise you would have rejected by saying that the entering prayer refused. Or don't pray for it at all.
3/6, 3rd June. Item 20.
This is questioning the legality of the Land Acquisition Act. They have said something.
Yes, madam, there are connected with petitions. All those matters are.
Mr. Borpajari, today you have made our job easy. By referring to such cases where we have vetted. These are difficult matters. No? Let this case be listed along with WPC number 6650 of 2025 on 23/3/2026. Correct?
Yes, sir.
उनको एक copy दे दीजिए. He looks dazed. Show this copy to him. He doesn't know what's happening. It's similar matter we have kept on 26.
I'm so obliged.
Till that lordship, petitioners shall not be dispossessed from his lodge.
Have we?
लेकिन you can on all cases there are interim orders.
Yes, my lord, I can, my lord, there.
Interim order इसमें कैसे होगा?
Interim order, my lord, only in 2 matters, my lord. My lord, matter pertaining to, my lord, the petitioner.
Constitutionality of an act, what interim order?
Well, they are possession.
In the meantime, the status quo with respect to the petitioners, the status quo with respect to the possession of the petitioner shall be maintained.
Yes, well, only to that.
But that also is not proper.
Yes, well, otherwise.
My view is very different.
Yes.
Legislation, if it is challenged, no interim state must be heard today.
Therefore, my lord. In all that bunch of writ petition, my lord, save hand except 2 matters, there are no other interim orders. Only in 2 matters, my lord, this honorable court was
Of course,
So
not
you fixed it
dispense,
on
my lord.
23rd.
Yes, only with leader to get.
Conclude on that day.
My lord. I'm so obliged.
नहीं नहीं तो did we give any reason? No. व्यवस्थित किया करता तो नहीं है.
But it was earlier, isn't it?
Yes, but only in those
Not
two
by
bench.
this bench. Yeah.
Not by this bench.
No, not by this bench, not by this bench.
And this
And-
bench is
and we
very
followed-
good.
We followed that in another case, only in one case.
Yes, yes.
So, Mr. We are not passing that entire order.
Status quo.
To my mind, it is incorrect. That time we may have erred once because in deference of earlier predecessor bench, otherwise we don't.
That day when
But then it will become infructuous. Chalo, ठीक है. 26 be ready.
20. I'm so obliged.
Just see the order. When?
My lord,
This date is fixed on
23rd of March, man. This
25th of March, yes.
this week's to go. Yes, coming 20. I'm so obliged. Rakho.
Item 22.
May I please, Your Honor?
One, yes. Item number 22.
22.
Yes.
It's not before your lordship has to challenge the order of the applicable tribunal, my lord, which is filed under section 17 of the Surface Act, my lord, which was dismissed by the tribunal, my lord, whereby, my lord, this demand notice and position notice has been challenged, my lord. And my lord, the arbitrary in that order, my lord, is that, my lord, the petitioner's, my lord, credit card loan and the home loan has been clapped, my lord.
Go for before the appellate tribunal. Any reason? कुछ भी है, you go before the appellate tribunal. We can't help it. After some arguments, don't take any order from us. After some arguments, Mr. So and so. Mr.
Well, S. Hazarika. S. Hazarika, my lord.
Mr. Hazarika, S. Hazarika, and the advocate seeks permission to withdraw this application in order to enable the petitioner to approach the DRAT, पूरा लिखना, Debt Recovery Appellate Tribunal, if so deemed necessary. Dismissed as withdrawn with the liberty of first.
Obliged, my lord.
So,
Item 23.
yes.
Lordship, this petition is by Union of India and its instrumental it is Lordship. Here, Lordship, the respondents were appointed on purely temporary and contractual basis for 2 years, and subsequently it was extended. And on 31/10/2020, their order, their
1 second, give us 1 minute.
Lordship.
Principal, principal. No, next, the center account, the challenge, 246, Gauhati.
The impugned order is at page 218. Sharma?
Lordship, by the authorities, Lordship.
Impugned order by the CAT tribunal.
Lordship, 208. 145 and 208.
That's a confused correct from now. Talk about much more.
This is second round. Firstly, there is
No, which order of CAT is under challenge before this court? Please give us the page.
that is 246.
That is what we were saying. That is what we were saying. Look at this. We are the kind of bench, if you try and confuse us, I mean, inadvertently also we'll dismiss the petition. Normally, when I, as a lawyer, used to confuse the bench, I got positive relief. But unfortunately, I have
No, Lordship, I'm not trying, Lordship. I thought
if I'm confused even a bit, I will straight away dismiss the petition. Therefore, you have to be very specific here. As a lawyer, I always succeeded in confusing the judge and getting on it. As a judge, I don't get into fall in that trap. No? Shows the impugned order.
Starts from page 246.
So this is the one that I was asking you to point out. Previous litigation. Just a minute. Vacancies. Extension of a court. Look at this. Look at this order. Look at your stand. You don't pay, you don't give increment saying that well, the term has expired, but we are continuing taking services because of the court order.
Right.
The court order or no court order, that was extended, no?
Lordship, they are working.
Extended.
Lordship.
And the court had given you the permission, the principal bench Delhi. The court means the tribunal, principal bench Delhi, said that subject to the availability. You're taking work, you'll not give him even increment. He's not asking for regularization.
No. Annual increment. No.
Then what order is read paragraph 22 of that order.
It is evident that the positions so advertised for by NELIT are of a permanent nature and due process of written examination followed by viva voce or interview was followed. Thus, selecting the applicant along with others for the various positions so advertised for appointment on contractual basis. The applicants were very well aware that these positions against which they are engaged are of contractual nature.
That is that recession that you don't, your organization is not behaving like a model employer. What ground have you taken? We are slightly apprehensive of issuing notice and passing an interim order for the reason that you will choose to dismiss them. You will say that we don't require. This is a bullying tactic. Bullying tactic. But why do we interfere? Read paragraph 22 and 23. I think we are in agreement.
Lordship,
you don't behave like a model employer. And what is this? Read paragraph 22. We'll allow you to argue, please. But first you satisfy us. I mean, this is what is coming to our mind straight away.
The finding is that this advertisement, but the very
read paragraph.
Lordship. It is evident that the positions advertised for by NELIT are of permanent nature and due process of written examination followed by viva voce or interview was followed. Thus, selecting the applicant along with others for the various positions so advertised for appointment on contractual basis, the applicant were very well aware that these positions against which they are engaged are of contractual nature and after their period of engagement will be over, they will be released accordingly. As per the statement made by the respondent authorities that they do not intend to discontinue the services of the applicants on contractual basis till the requirement under their various projects within the country. Accordingly, Honorable CIT Principal Bench passed order dated so-and-so with the consent of parties that applicants continue to be engaged under various projects of NELIT. However, they will have no specific right for regularization. Accordingly, the services of applicants were continued after their initial engagement term was over on 30/10/2020. However, they were not paid their salary since then. Also via their impugned letter dated so-and-so, their annual increment was denied, stating that the original terms and conditions were for the contract which has already expired. However, as per the direction of this tribunal principal bench, their services were continued in the original advertisement for the position against which the applicants were working. There is no specific project against which applicants were engaged, and the position against which they have been engaged includes so-and-so are of regular nature. Thus, as they have worked under NELIT for around 5 years, with original terms and conditions, including annual increment after completion of 1 year, the same term and conditions should have continued for their further engagement under various projects in NELIT. The original terms and conditions will govern the applicants throughout their engagement in NELIT unless they are engaged on fresh contract. As the respondent authorities have averred their intention that they are not discontinuing the services of the applicants even after the original engagement till October 2020, and the applicant will be engaged as per their suitability and requirement and qualification under different projects. The applicant have already contributed and worked in the organization for around 10 years and have developed their expertise accordingly. This may be utilized by the organization.
Why have you challenged it? It's heavily loaded in your favor. Heavily.
Lordship.
Except for a minor observation here, that the terms of the contract would continue as if it were a fresh contract, unless you enter into a fresh contract. That's the only thing, and that's very logical. But rest all is in your favor.
Lordship.
Why have you challenged it?
The regulation part already dealt in the principal.
Challenged it.
That annual increment part, Lordship.
What? No. Consider you talk to your client. Then we will come down with a specific direction that we dismiss this saying that we agree with this.
That only for that part. That others is our favor, Lord. That has already
loaded in your favor. Yeah, but so we are dismissing it. Unless you seek 1 day's time, you can take instructions of withdrawing. Dismissal would be bad. I don't think, what kind of an employer are you?
Lordship, I passed the order. Already that's part.
We are discussing. This one. And with the specification that the order should be complied with.
Some time may be given, Lordship.
No. Challenge. Take an interim relief from Supreme Court.
Okay.
Item 24.
In 24, we have filed a affidavit. While that the whole Assam State Jew is under.
Let him first speak. What is the matter? Let's see what's the matter. Where is Mr. Potako? You are representing Mr. Potako?
Yes.
For the forest department?
Yes, madam.
Put in the affidavit of care for response 1.7 with respect to modification in terrorizing the dimensions. The disclosure of the employer, the animals have been kept in the assembly. Has it been filed?
Yes, madam, we have filed.
Have you received a copy of the same?
Yes, Lordship.
Batao,
Yes, Lordship, on the last date, Lordship has asked for the legal backdrop of the case. So here is the guidelines that I'm asking for complaints.
We are looking at the zoo rules. Is
Yes.
there any rules for zoo? rules?
Yes, everything is mentioned in the preface of these guidelines.
You are
Preface
asking
and
me to
in the
answer
first,
that.
yes, Lordship. Preface and in the first page.
It is rules.
And what have you said with respect to these?
Madam, these are the statute, madam. These time rules I'm handing over, statutory rules, madam.
So what is your affidavit? Does it?
Our affidavit says, my lord, we are overhauling the zoo. We have floated a tender for what already given for rupees.
Is that his allegation? His
Three,
allegation, he doesn't say that a wrong man has been given the tender.
No,
He says that the dimensions you're changing now.
Lordship.
You're reducing the space in which a monkey could live, or maybe a bear could live.
Madam, the affidavit we are saying, since we are going for complete overhaul of the zoo, we are taking care of everything.
Now, where is that statement? First, that statement.
Paragraph 5 and 6, my lord.
First, tell us the page number.
Page 64 of the affidavit. Small affidavit.
Small
Five.
affidavit.
Very small.
Or cryptic affidavit. Read. Who has shown the affidavit?
My lord, this is the director, my lord.
Yes, read the relevant portion.
My
Read
lord,
paragraph.
reading paragraph 5 minutes. That at the outset, it's most humbly submitted a white work order that is so and so. The Office of the Chief Engineer, Public Works Department has awarded tender for modernization of Assam State Zoo and Cum Botanical Garden, which is valued at rupees 345 crores, which is expected to be completed by 29/11/26. Copy of the work order is annexed, my lord. And para 6, the aforesaid project is aimed at modernizing and improving the overall infrastructure for animals, staff, as well as visitors of the Assam State Zoo, Cum Botanical Garden. In the said project, specification with enclosures is also being subjected to a major overhaul, and keeping in view guidelines on minimum dimensions of enclosures for housing exotic animals of different species is issued by the Central Zoo Authority under the recognition of Zoo Rule 2009.
Where did you get, Mr. Counsel, where did you get this information from?
Yes,
It has not yet been made. How do you say that the dimensions have been reduced?
No, the dimensions from the initial stage, from right when the zoo was made, they were not compliant, and those dimensions they're provided in the RTI, Lordship. It is there in the main PI.
Where did you see? Did you see the drawing of the type? Structural design?
The zoo issued the RTI reply, and in that reply, they have mentioned that those dimensions are not in compliance with the guidelines.
They have said so.
Yes.
Where is that RTI disclosure?
Lordship, in the additional affidavit.
Page? This affidavit assures us, the affidavit that Mr. Gogoi was reading out,
They
assures us that the rules in that regard will be followed. But if you have something else to say,
No, they are saying that now they will carry out a major overhaul, but right now, as if today, they are not in compliance with that.
So therefore, you have to wait. They will not make piecemeal arrangement.
Yes, yes.
300 crores and odd has been sanctioned. They will make it. I think it was the case. How was it better to be filed before? I mean, this doesn't qualify for public interest litigation now. He will get an opportunity. We'll leave that option open for him. In case you find something after the tender, where the design is passed or something.
Yes,
I think
the court should keep the case alive. The court should keep the
Gogoi has not annexed their drawing.
Where is that drawing?
Where is that drawing?
That is a part of the DPR, my lord. Because initial.
Don't make such casual statements.
No, my lord, that is a.
This affidavit is not small. This is cryptic. You tell us.
Yes, very vague and general.
My lord, no. My lord, I'll address the question. My lord, what had happened? Gauhati Zoo also acts as a rehabilitation center for animals which are mostly smuggled animals which are routed through Mizoram, my lord. That border. So sometimes some instances are there that we have some animal which doesn't find mentioned in any schedule, my lord. Those exotic animals has to be some makeshift arrangement has to be done. That is, I have spelled out in paragraph 7, my lords. Otherwise, we have to look, we are
This
doing a.
is not, these grievances is not properly done. Your stand is that we will overhaul it, everything will be followed.
Yes, yes, ma'am.
Is that it?
My
We are happy with that. But only thing is that had you have annexed this, drawing that this is our project, matter will be ended there.
Yes.
Because this remains many other scopes, next litigation, you will start construction, you will come and say this is not there, again stay.
Then once the work commences, then the funds will be lost.
I will bring the document.
Direction to the responsible authorities to comply comprehensively with the parameters, the guidelines on minimum dimensions of enclosures for housing of aquatic animals of different species issued by the central authority. Yeah, this he has answered in 7, that this also will be taken care of, but as of now, because of the exotic animals being transferred from different places, they are kept in rescue compartments, which may not be as per the standard. Completely understandable, but they're making, so these rescue provisions that you'll be making in a zoo,
My lord.
or maybe for exotic animal,
My lord.
that also will be taken care of.
Yes, yes, madam. Yes, madam. Because there is an organization of CITES, my lords. Many animals which are exotic were not in the schedule of the Wildlife Act. By 2024 amendment, we have brought those animals on the schedule, my lord. So those keeping in mind, my lord, these are being carried out.
Yeah, even the other states are involved in that here.
Pocket common fuel. It remains in pocket when it can be sedated for about 6 hours. So that's not occurring.
If the details of the newly awarded.
This could type of
Mr. Gogoi, that overhauling in the same place or somewhere else?
No, no, same place. Same place going on.
What is the name?
Procedure work guru.
Mr. We have heard Mr. P for Goa. Now, a petitioner in person. Mr. D. Gogoi. County Council Forests. MS M. Pichi, Additional Attorney General, Nagaland. And Mr. M.R. Adhikari, where is he? Mr. M.R. Adhikari, for response number I-689. This public interest litigation has been filed for the benefit of all the animals, birds, and various living creatures held captive in the zoos maintained by the respondents, as they are incapable of approaching the courts themselves. A specific prayer has been made in this writ petition for issuing directions for 100% compliance, 100% strict compliance on every parameter of the guidelines on minimum dimensions of enclosures for housing exotic animals of different species issued by the Central Zoo Authority under the recognition of zoo rules 2009 in letter and spirit within a fixed time frame. The response affidavit of the SC Forests indicates that a decision has been taken at the governmental level for an overhaul of the zoos located in the state of Assam. A work order has been issued by the Office of the Chief Engineer, Public Works Department building, for modernization of Assam State Zoo Botanical Garden, valued at rupees 345 crores 67 lakhs and 50,000 only, which is expected to be completed by 29th of November 2026. Mr. Gogoi has informed this court that the project in question is aimed at modernizing and improving the overall infrastructure for animals, staff, as well as visitors of Assam State Zoo Botanical Garden. In the said project, the specifications of the enclosures are also being subjected to a major overhaul, keeping in view guidelines on minimum dimensions of enclosures for housing exotic animals of different species issued by the Central Zoo Authority under the recognition of Rules 2009. With respect to the housing of the exotic animals in crammed spaces, the affidavit in question indicates, the affidavit under our perusal indicates that Assam State Zoo Botanical Garden serves as a rescue and rehabilitation center for wild animals in distress, especially the exotic animals rescued from smuggling attempts by illegal traders of international markets caught in anti-smuggling operations. These exotic animals are kept in rescue chambers for their ultimate rehabilitation or permanent shelter. An assurance has been given to this court that in the general overhaul of the zoo, all efforts shall be taken to even upgrade and align such rescue centers with such rescue spaces with the dimensions, the statute, with the guidelines and rules on minimum dimensions of enclosures for housing of exotic animals of different species. With this assurance, this court is satisfied that the issue raised by the petitioner has been taken care of. However, before closing this petition, we do observe that in case the petitioner finds from the drawings / structural design or any other material that such guidelines are not being resorted to, it will be open for the petitioner to revive this petition by filing a 2 pages affidavit. In which situation, this writ petition shall be revived.
But Lordship and the other states,
For the present, the petition stands closed.
the other states, Lordship, for other zoos.
Okay, this will take care.
All right.
Deeply obliged.
This will take care.
Wait, with your lordship.
Yes.
One of this matter relates to election to the post of President of Anchalik Panchayat.
Mr. Chaudhary, give us 5 minutes. We'll go through the order dated 19/12/2000. Open chair. Yes, Mr. Chaudhary.
Pursuant to your lordship's order, the election was held.
Pursuant to the single judge.
Yes, my lord. Which has been, my lord, in this order your lordship has directed. Then, my lord, the respondent number 1 has been elected. And my lord, my client has handed over charge. That is the, my lord, factual position. Now, my lord, the issue before your lordship, in my, my lord, humble submission, will be to determine, my lord, whether, my lord, section 46.
Now, in this case, whatever may be the situation, the applicable rule would be 37 of 1994 rule, 1994 Act and 48 or 46 of the 1995 rule. It has got nothing to do with 46.
46,
Nothing to do with 40.
My lord, I'd like to address on that.
But then that's not required. Mr. Chaudhary, now good, bad, indifferent, a date was fixed where everybody was noticed. And you are not raising any issue with respect to the number of votes required. The meeting being 4-8, whether non-elected members also could vote. So in that case, we are left with no option but to close this.
My lord, my submission.
I am telling you, your submissions we will hear, not that we are gagging. The question is that reading our own order, we find that we unnecessarily traverse towards that. The matter is simple. You see, every day is a learning experience. I don't know why we passed an order and gave a tentative opinion. Question is that Section 37 of 1994 rules and 48 of the 1994 Act and Section 46 of the 1995 rules. These read together, they exclude the applicability of Section 46. So far as first meeting, second meeting, there is no, it should be quorum. There should be quorum. Now that everyone has been noticed, elections have been held, we would not like to unsettle that. And your movement was cancelled otherwise also. Will not like to do that. Let it function. Now, these are academic questions. Why do we enter in?
May I make my
Yes, now you begin.
Firstly, my lord, the rules have been framed under the, my lord, 1994 Act, Section 111. And this subordinate legislation is only to, my lord, supplant or, my lord, supplement whatever is, my lord, there in the Act.
It is not available to you. Once the rules have been made, it must be followed. The rules have been made under the Act.
No, my lord, if I can satisfy your
You
lordship,
can't say that it has only persuasive value.
my lord,
Or it is for the ease of business. These are rules which must be followed.
my lord, if I can show your lordship that the, my lord, the rules, Rule 48 particularly, my lord, that, my lord, it contradicts the provisions of the Act.
It doesn't. Question the constitutionality of those rules.
No, it's not a constitutional. The Rule 48 does not.
No, if two provisions of the Act are inconsistent, contradictory, then one has to go, or harmonious construction has to be adopted.
Yes, my lord, that harmonious construction, I am on that, my lord. Now, my lord, the Rule 48, that, my lord, does not speak. That, my lord, in the adjourned meeting also, you have to have the quorum.
We don't want to enter into this dispute for the reason that now with notice, elections have been held.
Maybe, my lord.
You have garnered lesser number of votes than Mr. Monta.
But at the, my lord, the initial point of time, my lord, I was elected. I was elected.
But then there was question, the court interfered, and the division bench did not, put any interdict, did not stay. And now with the elections, I don't think. Now wait for some no confidence motion if the province says so.
My lord, my submission will be your lordship will decide the matter as of the date of filing of the writ petition, my lord.
That is true, but we are not going to do that for the reason we can record this submission. We can record your submission, then we can give our answers. Because the whole purpose of the cooperative is to begin functioning, and within a particular time must start.
Well, in the event your lordship allows my petition, my lord, the cooperative society functions, my lord.
Do you think it is possible?
My lord, if I can.
We did not stay the operative portion of the order of the single judge. We were not very comfortable with the judge fixing a date. We were not very comfortable. Therefore, those observations were made. Those observations were not necessary. We should have straight away decided, forget about whatever happened. Now, if there was some doubt that the members were not noticed, he fixed a date. Not that the division bench capitulated, but then realized that, well, after notice, I think everything would be fair and clear and straight.
No, my lord, the question here is, my lord, whether the election in which I was elected, my lord, whether that was proper or not.
That has become old. It's times with the passage of wind and water.
My lord, the Rule 48 doesn't say that, my lord, in the adjourned meeting also there has to be quorum. That is not said, my lord. It's not that, my lord, your lordship say the side or this challenge has to be made.
Come to 48.
My lord.
We have quoted it. No. Election of president and vice president. Please read. Let us have first 37. That tentative opinion of ours was unnecessary. We are confessing it. We came out with, my brother is right, that day he did not interfere. We came out with the third case. I tell you the reason why we went astray. We went astray because we were not comfortable, I repeat, with the judge, with the single judge fixing a date.
That deserves to be stayed, my lord.
But ultimately, good sense prevailed upon us, we did not stay. Now let the good sense continue and we don't interfere.
Now, your lordship was saying, my lord,
I didn't see it, Mr. Chaudhary. The bench has very broad shoulders to admit that we unnecessarily strayed in that field. Unnecessary. You could have put our, hammer there on. If not, we will allow this with complete notice. Matter has been decided. This is why people say that learning is every day's experience.
That I agree with. But then, my lord, I'll try to satisfy your lordship.
अब क्या satisfy करना है? आपने मैं 48 दिखाई है. पहले 37
Well, section 37, your lordship may kindly read, my lord. This is the election to the president and vice president.
No, let us first read 37, page 50.
My lord. The directly elected members of the Anchalik Panchayat shall elect from among the directly elected members who, two members.
Directly elected.
No.
This clears the situation.
Yes,
the directly elected members of the Anchalik Panchayat shall elect from amongst the directly elected members. Members is president and vice president.
In a meeting which is called the first meeting of the Anchalik Panchayat to be convened by and presided over by the deputy commissioner.
I think we are concerned with 37(1). Now let us come to the rules.
If there occurs vacancy in the office of the president.
Let's come to the rules now.
Now, my lord, before coming to the rules, my lord, your lordship may also, my lord, kindly go to section 46. That is important, my lord. Quorum of the Anchalik Panchayat.
46.
Quorum of the Anchalik Panchayat meeting. 1/3 of the total number of members of the Anchalik Panchayat shall form the quorum of transaction business at the meeting of the Anchalik Panchayat. If at the appointed time the meeting a quorum is not present, the person
Election
present.
of president and vice president would not form part of the transacting business at a meeting.
No, if at the time appointed
This
for
is
the
where
meeting.
we fell in error.
My lord.
This is where we fell in error in our interim order.
Your lordship will kindly read further. But if within such period there is no quorum, the person presiding shall adjourn the meeting to such hour or some future date as he may fix. He shall similarly adjourn the meeting at any time after it has begun. If in his attention wrong.
Please stop at that.
My lord.
We cannot proceed on this that this is applicable for appointment of for selection for election of president and vice president. This cannot. Because you see, one thing is very clear under section 37. Before coming to 46, 37, the voters, the electoral college would be of elected members. The candidates will be elected members.
Yes.
Correct?
Yes.
So if elected members, khatam. Now this forum is for transacting business. Business transaction is not only with the elected members. Business transaction is not with the elected members. Therefore, we would say that 37 is an independent standalone provision.
My submission will be,
46
my
is
lord.
a general provision. Then, now before we read 46, let us read 48. 48. Rule 46 or 48. Rule 48.
My lord,
we'll come to it. We'll come to Rule 48.
My lord, before that I submit, my lord, that this section 46, my lord, the transaction of business in the first meeting is, my lord, the election of president and vice president. That is the business, my lord.
1/3 of the total members of the Anchalik Panchayat shall form a quorum of transacting business. See, reading this with section 37 makes it very obvious that this transaction of business is not the business transacted in the first meeting for election of president and vice president. Please, let us have things very clear.
My lord,
where there is no dispute, we should not create a dispute.
My lord, in the first meeting, the business conducted, the transacted is, my lord, the election of the president and vice president.
Had it been so, then 1/3 of the total members, they would not have said this goes against 37.
So 1/3 is the, my lord, the electorate.
One third, where is this? One third of the total members. Please read carefully.
Yeah, so 1/3 of the total members mean, my
Total
lord.
numbers of members of the Anshalik Panchayat. Does it say the total number of elected members?
No, my
It
lord.
isn't.
No, they are, my lord.
37 is a standalone provision. That is how we see it today. And correctly so.
My lord, then your lordship was reading, my lord, Rule 48. Next,
Then come
Rule 48 says, my lord, Rule 48, first provision, my lord, first clause. The deputy commissioner.
What bit of the rule?
Rule 48, my lord, 203.
One second, sir. Now play.
The deputy commissioner or the officer authorized by him in this behalf under subsection 1.
1 second. Once. Let me come to the thing. 194. Yes.
The deputy commissioner or the officer authorized by him in this behalf under subsection 1 of the section 37 of the act shall, as soon as possible after completion of the election as under section 32 of the act, convene the first meeting. So this is about the first meeting. Then your lordship may come to subclause 3. If 1/3 of the total number of members as under subsection 1 of section 32 of the act called to the meeting under subrule 1 are not present within an hour of time fixed for the meeting, the officer shall adjourn the meeting pending fixation of another date. This says, my lord, 1/3.
The way which you can harmoniously construe this is that 48.2 and 48.3 have to be read adjustem generis. If it has to be read adjustem generis, then it is for the purposes of administering only. So far as election to the president is concerned, the governing provision will be section 37, read with 46.1. Correct? This is the safest interpretation applying the golden rule.
Golden rule of my
What is
lord.
that rule which avoids mischief? Hayden's rule. By bringing in Hayden's rule and applying the golden rule of interpretation, this is the only harmonious construction that we can apply.
But then, my lord, in the rule 48, my lord, it doesn't speak what will happen on the adjourned day. There is silence on that.
Now that question, so far as Mr. Chaudhary and Mr. Mahant are concerned, that's over. We did not stay that. And had we stayed, perhaps we would have committed a mistake. Both ways. In fact, we should have said that this fixation of date by the learned single judge was incorrect. It should have been fixed by the authority, by the members. So therefore, 2 and 3 have to be read adjustem generis. 4 again can be read as well.
My submission with your lordship is that, my lord, when the subrule 2 and 3 of
Look, we can't derogate from the position that this election has to be by an electoral college comprising elected members. No doubts. Therefore, this 1/3 is out of question, 1/3 of the total number. So therefore, 48, rule 48 subclause 3 does not apply to the election provision.
If your lordship holds that, my lord, I don't have a case. If your lordship
That
holds
is what we are interpreting. No,
No,
you
my
don't have a case
that.
otherwise.
My submission with your lordship is that,
Submission
my
is
lord.
already, we are answering you, no? It is your submission, we are giving our submission. Now tell us whether we are wrong.
My lord. Rule 48 does not speak of an adjourned meeting. So, my lord, if there is an adjourned meeting, then, my lord, section 46 will come into play.
That is out of question, no. Because of all this argument, learned second judge got detract, and we also, to some extent, the question is that 37 is the controlling provision. This has got nothing to do with, we don't have to read 47, 46.
Section 37.
Section 46, we don't have to read. Quorum of the Anchalik Panchayat meeting.
That is where
This is
my
for transacting business. In business, we will not say that election of these members would form part of transacting business.
if your worship holds that, my lord, your worship will record that.
Huh?
Your worship will record that, my lord. There is not a- my lord, the election.
Expect Mr. Chaudhary that we will close the petition. We record.
I'm sorry, my lord. I'm sorry. What I am submitting is that.
It is not that we are deciding to close the petition, no? It is just a question of interpretation. We have done that. Last time also we did that. Today also we will do that. You don't, normally what happens.
No, this will settle minor future disputes. So that's why my submission is.
Future disputes we are not concerned with. As and when it comes, we will decide. But here, for the purpose, we don't lay down law. Here we will say that for these practical reasons, we don't want to interfere with the new result, which you can question now. And you can take a chance. You question that. Those we are not doing. What do you do?
I don't have to repeat, my lord.
You don't know. Let's then conclude it. Thanks. You have heard Mr. N.K. Chaudhary and senior advocate and the appellant. And Mr. So-and-so for respondents number so-and-so. The judgment impugned in the present appeal is dated 15/12/2025, passed by a learned single judge of this court in WPC number 4272 of 2020. Nair Ralga Anchalik Panchayat, Dhubri, bracket number 5, was constituted on 7/5/2025. And for the first time, a meeting was held on 11/7/2025, meant for appointing the president and the vice president of the said Panchayat.
My lord, may I take leave, my lord?
But then who will judge that we have incorporated all your arguments?
Your lordship, I know, my lord.
All right. You can always come for a modification of the order.
will
And
not-
this ground was not raised. Therefore, we insist for the lawyer to be present here, ask a junior to be here. And to remain vigilant, we don't miss out on any one of the grounds raised by him. Correct? ठीक है, you can go. क्या लिखा है pro? Meant for electing the president, not appoint, meant for electing the president and vice president of the said panchayat. On that day, there was no quorum available. And therefore, the meeting was adjourned to 15/7/2025. On this adjourned date, back at 15/7/2025, 6 persons were present who voted for 2 of the members as president and vice president of the said panchayat. Who are the appellants before this court? The respondents questioned it. On the ground that there was still lack of quorum on 15/7/2025, and that they did not have the notice of the adjourned date on which meeting was to be held. The learned single judge on the aforementioned grounds, namely the meeting being non-orate and no effective notice to the writ petitioners as respondents, set aside the election and directed for a fresh election on 29/12/2025, which date was fixed suo motu by the court. Suo motu में spelling कैसे लिखते हो suo motu? Suo was fixed by the court. While reviewing the aforementioned judgment, while assessing the aforementioned judgment, while evaluating the aforementioned judgment, this court was of the view that the date for next election ought not to have been fixed by the learned civil judge and should have been left to the authorities with effective notice to all the members for attending such meeting. Be that as it may, the order passed by the learned civil judge was never interfered with, and the elections were held on 29/12/2025, where respondent numbers. Mr. Mahanta, respondent number 1. No, there are 2, no, president and vice president.
President, vice president, vice president. Vice president, I'm not asking president, vice president.
Where respondent number 1 and another were chosen.
Election held on 12/1. That meeting was abdomen.
12-1. Finally, it was 12-1. It was.
Okay.
And he contested also.
Calicut. Elections were held though on
12/1/2026.
12/1/2026, in which respondent number 1 and another were elected as president and vice president of the Archdeacon Panchayat.
And the appellant contested in the election.
Needless to state that the appellants had contested that election. This closes the issue for the present. But on the insistence of Mr. M.K. Chaudhary, learned senior advocate, further discussion is made so as to clear doubts whether, for the purposes of election of president and vice president of Archdeacon Panchayat, Section 46 of the Act of 1994, which deals with quorum, would be applicable, or would it be governed by Section 32 of the Act, read with Rule 46 of the 1995 rules. Sabka detail likh dena. Rules, 1995 rule. Section 37 of the Act of 1994 clearly provides that the directly elected members of the Archdeacon Panchayat shall elect from amongst the directly elected members 2 members as president and vice president respectively of the Panchayat in a meeting which shall be called the first meeting of the Archdeacon Panchayat, to be convened by and presided over by the Deputy Commissioner of the district in the manner prescribed. The manner has been prescribed in Rule 46 of 1994 rules, Rule 48 of 1995 rule, of the rules of 1995, which are being extracted herein again for the sake of clarity. Mr. Chaudhary, learned senior advocate, argued that a composite reading of Rule 48 referred to above would definitely give an impression that the electoral college would consist of 1/3 of the total number of members under subsection 1 of section 32 of the Act. And therefore, there remains an inconsistency in reconciling the different provisions of the Act and rules so far as the election of president and vice president or the first meeting of the panchayat is concerned. We also deem it necessary to reproduce Section 46 of the Assam Panchayat of the Act of 1994. For clarity. With a specific provision contained in Section 37 of the 1994 Act regarding election of president and vice president of monthly panchayat, there can be no manner of doubt that such election has to be held in the first meeting or in a meeting which is held for the first time after constitution of the panchayat for the purposes of electing president and vice president, which would be deemed as first. And that the elections shall be held, the electoral college would be of the directly elected members and the candidates would be also the directly elected members for such posts. The provision contained in Rule 46, therefore, would not be applicable for the first meeting of a newly constituted panchayat, where president and vice president of the panchayat are to be elected. The procedure for election at the first meeting, as contemplated under Section 37, would be in accordance with Rule 48. Which has been quoted above. The rule emphasizes that there should be clear notice. There should be notice of at least 7 clear days of such meeting. And before the elections are held, the members present before the commencement of the meeting would be administered oath. So far as quorum for the meeting is concerned, Rule 48(3) postulates that if 1/3 of the total number of members as under subsection 1 of section 32 of the Act called to the meeting under sub rule 1 are not present within an hour of the time fixed for the meeting, the officer under sub rule 1 shall adjourn the meeting pending fixation of another date by the deputy commissioner, not later than 15 days from the date of such meeting. Would it then indicate that the that the quorum for such election would be 1/3 of the total number of members as contemplated under section 1 of section 32, under subsection 1 of section 32 of the Act? Perhaps Rule 48, sub rule 2 and 3 of Rule 48 have to be read adjusdem generis. That is, such a stipulation would be applicable for the purposes of administering oath to the newly elected members and not for constituting the electoral college or making or the qualification for any elected member or qualification of any member to contest for the election, which according to section 37 of the Act of 1994 would be available only to directly elected members and not all the members. Seen in this background, it appears that the learned single, it appears that a fresh elections were held. The date being the court, the date having been in the date in the first instance having been decided by the court, but later changed to another date when elections were held, where the appellants and the respondent and another contest. In this view of the situation, appellants having garnered lesser number of votes, he is getting 4 votes, I am getting 7. Lesser number of votes, bracket 4 votes, then respondent number 1 who could obtain 7 votes out of 11 elected, 11 polled votes, 11 polled votes of elected members. There is no option. Nothing remains to be decided in the present appeal. Nothing remains to be decided in the present appeal. For the aforementioned reason, we close this appeal with the observation that it would be open for the appellant to question the election, if so deemed necessary, of the respondent number 1 and another before an appropriate forum. The appeal stands disposed of. He has not raised that issue. My brother has come out with a fourth case. It says that this also should be bad because oath has not been administered. Unless oath is administered, there cannot be any election. He has not raised that question. Tell you next.
Item 26.
Yes, what do you have to say?
There's another repetition pending in respect of the identical question is identical.
How many petitions are you filing against the person?
There is an order.
Say if you do all this, then we will impose fine.
There is a,
for Tinsukia district. It is for another is for the.
You're the same.
the record says Assam, Bezara, 166.
Let this matter be listed along with WP number
166 of
166 of 2026. When is that slated to be listed?
30th of April.
30th of April. Right.
Item 28.
Yes. Yes.
Lordship, I'm appearing for the sole respondent in this case, Lordship. Before my land court staff, may I address this honorable court? A series of matters pending consideration before the honorable court regarding whether intra-court appeal is maintainable in respect of an award passed by the land tribunal, penance tribunal. So I don't have the numbers, but it is pending consideration.
This case be listed. After the. It must be pending before us. Where is the, give us the number and date.
I'm not equipped with the numbers.
So please find out the number. You're not equipped. I just give you the petition undated, no?
No.
We will have it listed on a particular day. If there is no date, we will decide that matter and then we will decide this matter.
My learned friend had told me about this, so I asked him to make a submission. But here, whatever we have filed is as per High Court rules.
Let it be.
I know that there is an issue when if the court basically
I think it will lie. But anyway, if the matter is pending consideration, we'll decide. Give us the number. This matter along with those cluster of petitions to be provided by you.
Lordship.
By today.
I'll try. I'll give it to them.
Then otherwise we adjourn it tomorrow. Find it out and tell us.
Tomorrow, Lordship.
Tomorrow. As prayed for on behalf of the respondent and agreed to by the appellant, this petitioner, by the appellant. Let this matter come up for consideration, not tomorrow, day after tomorrow.
Yes.
Find out and tell us.
Item 29 and 30.
Yes.
Here on behalf of respondent number 3, finance and
Who is the respondent number 3?
finance and taxation, Lordship, we are filing the affidavit. It's in the process, Lordship. Lordship may take it up on any other date, Lordship.
As prayed for on behalf of respondent number 3, on the ground of the affidavit on his behalf, on its behalf, in the process. The matter is adjourned sometimes in April.
23rd April.
There is an interim order, Lordship, it should.
Interim order to continue in the meeting.
Item 32 and 33.
Where is the judgment, Mr. Chanda?
Well, I have brought it, madam.
How do you brought it?
And probably I need not travel to Delhi. Your lordship judgment also supports me. As in the case of State of Assam versus Dipankar Gogol. Apart from the judgment of the Supreme Court I have brought.
You will ask us to go through the entire compendium.
My daughter, I have brought and
उसको एक compile करके दीजिए. Give a nice compilation so that we can turn the pages comfortably.
Your lordship judgment of
Index and underline those relevant portions.
should I mark it, madam?
Yes. We are asking you to mark.
with an index. These are the judgments, basis.
The prime officer, tell me one thing. Now, that day I forgot to ask you. One thing. Now, when successive processes were carried out for limited examination, promotion, was the vacancy of 2019 also taken into account?
No.
Then we still have the authority to hear it.
And apart from that, your lordship specific query was that whether variation in numbers, because they calculated 125 and found physically 75.
We did ask you because our tentative opinion that day was that with this wrong projection of vacancy, the entire process gets a jolt.
It does not, my lord.
It does not.
Does not.
Very good.
Does not. First judgment even.
Give us 2 sets of compilation with marked lines.
Lordship will find. Chief judgment is, my lord, para.
Not today. Not today. Give us a compilation, proper compilation. Otherwise, we'll be reading through everything.
Or I'll highlight it, my lord.
We are asking you to do that. We are requesting you to do that. कल करेंगे?
Actually, my wife is, my lord, hospitalized.
पूछा ना, समय पूछा. आप बोलिए.
25, my wife
Your
is
wife
in
is ill.
hospital.
Your wife is ill.
In hospital, man.
Huh?
For 12 days.
Oh, then we will not force you to argue this today. Please look after your wife and then come back, give us a date, expected date when she gets well.
25,
Huh?
25 of this.
List this matter for final determination.
31st? 31st March?
31st.
March?
We, both of us wish your wife a speedy recovery.
Apart from, I have got the first judgment, the Supreme Court judgment, that if there is a variation in number for that, and
You got a specific judgment for that?
specific judgment. Specific judgment.
And which judgment of mine were you talking about?
That is in State of Assam versus Dipankar Gogoi. State of Assam versus Dipankar Gogoi.
Finally, fair.
There also your lordship says that examination cannot be cancelled just because of some alleged irregularities. Para, that is para 65, 67, 68. 65, 67, 68. And in their judgment, Supreme Court judgment, it is specifically said, merely some correction, variation of numbers.
No, for persuasive value, we don't require our judgment. We require Supreme Court judgment.
Lordship may just have a look, my lord, of your lordship.
After you give compilation, go to hospital.
I'll highlight it.
Oh, please.
Highlight it, those paragraphs. And specifically it is stated, what is your lordship query?
If that is not very burdensome on you.
Yes, my lord. And specifically it was stated that merely because some variation is made due to incorrect advertisement of numbers, that will not warrant cancellation of until there is a rule. Until there is a rule.
We'll see.
Very specifically it is stated. And that is stated in way back in 1999 by the Supreme Court and even in 2024.
Okay. Yes, we'll see. Give a copy of that compilation to Mr. Chakravarti.
My lord, I am right now, I am giving.
क्या करेंगे वो मान लीजिए सही है. What you're saying is correct. Suppose, in that case, where would your seniority lie?
Perhaps
after so many years.
Because I have brought
not born in that period.
I have brought a judgment for that specific query also after 10 years. I have brought a judgment on that also.
What?
After 10 years. After 10 years, that it was cancelled because of the pendency of the cases. It is lingered up to the year to 10 years. That is also I have brought. And here, my lord, only variation of numbers. Even headquarters are in our favor. Headquarters says, why don't you revise the...
Mr. Chanda, we will have to step up our air defense system. Your missiles are hitting us now.
Sorry, my lord. Extremely sorry.
Okay. Now we will step up our air defense system. To question that, give us those.
I like it.
But give it before the next date fix. Then
No, he's going to give tomorrow.
Tomorrow, day after tomorrow. Day after tomorrow, I'll highlight it. I'll place it with you.
And you just remind us that it has. All right.
Reply next. Reply first.
Item 34.
Regarding the requirement of 35% free equity. What is the RTA?
We decided some case on this, no? Was this the case where this was?
On the other day, my lord, I have submitted some decisions. My lord was pleased to say that my lord will go through the decisions.
We didn't go through it, I'm so sorry. But what does it say? Are you referring to Mardi chemicals? Mardia?
No,
But after that, there has been.
from Mardia Chemicals, in Mardia Chemicals, what happened, my lord? The
No,
Mardia Chemicals held
what is the current position? We know sunshine.
lordship.
We know sunshine.
Lordship.
Now, according to sunshine, if there is no fiscal determination, in a matter, then I think 18.2 does not apply, the pre-deposit requirement.
No.
That's what Sunshine says.
Okay.
Are we wrong? Very off the line.
I will praise my Lord for my submission.
Tell us, are we off the line? Sunshine says this.
No. Sunshine, my Lord, says that the matter is remanded back to the Bombay High Court. First, the matter is remanded back. It does not lay down. So for determination, my Lord was pleased to say whether when the determination is not done by DRT. Now, section 18 says, Lordship, determination or amount demanded by the secured creditor. There is or, whichever is less. Make it your order to section 18. Section 18 for a lordship. Provision 2.
Yes.
Provision 2.
Read the word of it.
First, section 18. Any person aggrieved by the order made by the Debts Recovery Tribunal under section 17 may prefer an appeal along with such fee as may be prescribed to the appellate tribunal within 30 days from the receipt of the order, provided the different fees may be prescribed for filing fees might be borrowed. Now, next one is important. Provided further that no appeal shall be entertained by the borrower unless the borrower has deposited with the appellate tribunal.
By the borrower.
Unless the borrower, sorry, Lordship, unless the borrower has deposited with the appellate tribunal 50% of the amount of the debt due from him as claimed by the secured creditor, or there is or determined by the Debts Recovery Tribunal.
Therefore, this is relatable to the amount which a borrower has to pay. This stays for Mr. Bhatti will come later, because his contention is that all the original documents are with him, and therefore no equitable mortgage has been created. Well, that comes later. Now, this issue can be decided only if there is a forensic examination of the document produced by you that this is genuine. Now, two persons are claiming two different documents to be genuine.
Yes.
This is the issue. Don't read anything beyond that. Don't lift the curtain. In that case, whether he would be required to make a pre-deposit, that is the question. Sunshine says, please make it meaningful. Sunshine says to the judges, please make it meaningful. Don't interpret it in a way, in such a narrow way, so that the whole purpose of appeal is frustrated. Now he is questioning, there's a huge amount, whopping amount, 50%, or you reduce it to 35% or 25% or whichever. Now the new rule says that it could be reduced to 25%.
It can be reduced.
But why would this be applicable? Why should it be made applicable? That's the issue. Why did you say what?
It is a mandatory provision law.
No, mandatory we have followed. Sunshine, therefore, again, we are coming back to Sunshine.
No, Sunshine says it is not. Sunshine has not laid, that is the law. Sunshine has not laid the law. He just remanded back the matter. Now,
Mr.
Page 94.
Page 94.
No, just a minute. Mr. Nandi,
Lordship.
That statement in Sunshine may be parenthetical.
Lordship.
But it is not side wind. It is not a side swipe.
Right.
On that issue. Let us come to Sunshine first.
Lordship. Para 15, page 96.
You have annexed it. I have annexed it.
The petitioner has annexed it.
Page 94.
96, Lordship. May I read?
No, 8 seconds. Come to para 14 and 15 and 16.
Yes, Lordship. The plain reading of section 18 of Surfacing Act referred to above would indicate that if any person is aggrieved, should also include the borrower is aggrieved by any order made by the DRT under section 17. We may prefer an appeal to the subject to pre-deposit. We are of the view that, of course, the prima facie, the expression any order should be given a meaningful interpretation, and should any and every order that may be passed in the DRT if sought to be challenged, be made a subject matter of freedom.
This was the poser.
Yeah.
This was the poser of the bench.
Yes.
Now let's say 16.
16. One can understand if any final order is passed by DRT determining the liability of the borrower or of any other liability. An appeal is preferred under Section 18 to the SURFACI Act to the appellate tribunal. The provisions of pre-deposit would come to play. However, if that would be the position, if an order of like one is present, declining to impede the auction purchaser in the pending proceedings before the DRT.
Now,
We are
you'll have to tweak your arguments, Mr. Nandi.
No.
You'll have to say, for us to consider, that this is a subterfuge. This is a process by which Mr. Bhatti wants the entire liability to be determined without making the pre-deposit, because that's the only issue which is left to be decided. Original document not being in possession of the lender, not being in possession of the bank, which the creditor. We have formulated the argument for you. You are again going here and there. Independently, the refusal by the tribunal of sending a document for forensic examination, I don't think for appeal a pre-deposit is required. But if you say that this whole purpose is a subterfuge, that's the oblique way in which the matter is sought to be determined, that this amount which is claimed by the creditor has to be paid by him, that would be decided with that issue. Then perhaps we can think up, tweak your argument a bit. Otherwise, independently of itself.
Firstly, Lordship,
you have not followed what we are trying.
He is a borrower.
No, तो आप ऐसा करिए. We will ensure that the appellate tribunal will assess whether correctly it was refused, and thereafter the matter would be decided by the tribunal whether he is liable to pay.
So far,
let it be sent. We exercise our powers under 226. We say that let it be sent for examination. Forget about DRT. No pre-deposit before I. You can't sort of hoodwink. No, get it decided. Why did you claim that you have the original when you have the law that even in the absence of the original document, equitable mortgage can be created? You have the law. Then you are making a wrong statement. Then you face prosecution as well. Where did you get the original from?
He has deposited and he is not.
So either he gets prosecuted.
Yeah, that is a fraud.
Just a minute. Either a petition under either a contempt fee or direct for filing of a under 195.
When he is saying he has deposited the documents which are by signing confirmation letter, he has deposited these documents in the bank. And we have verified it and verified the origin. We have also got a certified copy of those documents. Also.
How did you verify it with original? Original was lying with the registry office.
No, he has deposited the original, and then we have taken out a certified copy also to verify that authenticity of the same. And the sub-register also says it is okay. Now, if there are two sets of documents in original, then he has intentionally
fraud. Contested this, that send it for forensic examination.
And in the original application,
let the tribunal decide.
Yes, in the original application also he has filed a similar application. That was rejected. He has gone to DRT. That was also rejected. Then he came before your lordship. That was dismissed. So far, original application is concerned.
Dismissed on withdrawal, man.
Yes, dismissed on withdrawal. In the original application, in the marriage.
Withdraw the application valid, no application was filed.
In the original,
we don't accept that proposition. We are still wishing the view that if a petition is filed and withdrawn, that means the judges did not find favor in
So far in original application also concerned, he has yet done it. He went up to the DRT. And now, lordship, so far determination is concerned, after Siddha case, this honorable court
should not be a precedent, but let him contest let him file the appeal. There will not be a precedent, let him file it. Let that be assessed. Or if you agree,
I'm going to agree.
And if you agree And if you're really sanguine about your case, you make a disclosure here, we will say that let it be said. But for that, you'll have to agree. Then we exercise our powers under 226.
No, I cannot without instructions.
Without instructions. Now we are telling you now, forget about all these legalistic arguments. We are of the view that there should not be unnecessary reasoning adopted by the tribunal. This is only for the purposes of testing whether the decision to refuse sending it for forensic examination could be appealed before the DRAT without making a pre-deposit, which we are inclined to. So therefore, you take instructions. We can always ask the DRAT to decide the issue, say whether the court was wrong in such a difficult situation, because everybody must have a right, and everybody should have a right to vindicate its own cause. So that way, if Mr. Bhatti thinks that you are talking about some other apocryphal document which is not his, then even then he will have to pay. He has taken the money. He cannot doubt that. Today he is only asking for a soft option, and he has started all this. What we do is let it unnecessarily, it is being delayed at your, I mean, you are not getting that money. For clawing that money back, mind the expression which I am using, for clawing that money back from him through the process of law, you should agree for the forensic examination. Take instructions.
We are not disagreeing with forensic examination, but so far pre-deposit is concerned, Lordship.
Mr. Nandi, please don't argue that. Now, please frustrate his attempts to hoodwink you. Make some effort to let the bank take back the money from Mr. Bhatti. He's a cunning borrower. Not Mr. Bhatti, his client. He's a cunning borrower. And you have fallen in trap. You are opposing all this. Take a call. We have decided under 226 and say that why the bank also is, then we will have a feeling that you are also interested in allowing the amount not to be taken back from. Matter could be decided straight away, or hum decide kar dete hain, let the DRAT decide. And only that issue thereafter.
Lordship, I will file my written notes of argument. I'll leave it to your Lordship.
Written notes of argument for your safety, for your confidence. But then we would also ask you to take instructions from the bank.
Yes, so take instructions.
Written notes of argument, we will say that this we have said of our own. He has not conceded. That to safe hai, even without notes of argument. We will never put
From my part, I will file my written argument, then I will leave it to your Lordship.
Mr. Gandhi, you be rest assured, I come from the same source. We will never let an advocate face a difficult situation with his client with our order. When we pass an order, we will say of our own that this is what we are exercising. Without his consent, we are exercising this power on 226. Finished. We are not going to put you in trouble. But then take instructions. That is more important for us.
Let it be listed of 2 weeks.
As prayed for on behalf of the respondent, this matter come up for consideration. Please remind us, don't that day if we go astray, just tell us that this was the issue. You wanted, otherwise decide. Otherwise, हम लोग 18-2 और ये देखने लगेंगे. And the time will do it. Have you followed why we want this?
Yes.
Because of the cunningness of the borrower. He is only delaying the process. Mr. Bhatti must have suggested that.
Date, my man.
Is it on 18-2, my Lord has
Any day.
30.
30 April.
13 April.
You wanted that. You want a delay.
Let it be in the last week of March.
Yes, last week of March. We are clear in our mind.
Yes.
We just want him.
30th March.
Please take instructions today.
Yes.
That the court is of the view. Otherwise, it will allow it to be filed without a pre-deposit, with a stipulation to the appellate tribunal that just decide this issue, assess this issue, and decide it back to the tribunal.
Not true.
Your rights shall not be liquidated of recovering the money from
Yes.
under the law. Mr. Nand.
No, what the bank has.
Look at
Because
this.
Because
Mr. Nand, the easiest,
well, if your lordships,
the easiest
it should not be a precedent to other cases. Because
you're not understanding our endeavor. You're not appreciating rather.
we appreciate your
The
lordship.
easiest way to dispose of this appeal, which would be within the parameters of law, is to dismiss Mr. Bhatti's case.
That's
Citing 18.2, which we don't want to. The mechanical rejection means nothing. Why are we sitting here for under 226? And the tribunal is a we apply our mind and we think that it cannot be done. And that is keeping your interest in our mind. Why reject it? Suppose during the course of trial, during the course of something, two documents come and there is claim and a counterclaim. We'll send it for the moment it is asked for. We'll send it for forensic examination. The cost to be bought by him. Why not? Why hide? That is our concern. Why hide? In this world of transparency, why hide this? How far the assessment of the 100 forensic experts will be correct, that is debatable. But you are giving him such a long rope. Let you question it later. We are deciding it today. हम इसको डिसाइड कर देते हैं इतना लंबा क्यों समय दें?
As your lordship pleases.
चलो आप you want to give a written note next week?
I'll give.
As prayed for, but on that day we might change. We keep changing by hour.
No. Your lordship's mind never changes.
So next week, maybe.
In March.
It's husband's
Not true.
Supplementary list, item 37.
In this matter, I had filed my affidavit on 7th of November.
Your affidavit on
7th of November. And on 10th of November 2025. On 10th of November, matter got listed. My friend appeared. He paid for time to file his rejoinder. Then, on again, 18/12/2025, the matter was listed. It came under the column admission, notice served, reply not filed. I was very negligent. I should have checked up with the registry. Because I had filed my affidavit on 7/11.
Today the pleadings are over.
Yes, but no, because the affidavit is not on record. Due to certain defect in the affidavit.
Then file your affidavit.
Yes, but I'll pay for 6 weeks' time because there are certain defects which will get out.
6 weeks is longer.
Because why I'm saying this? Because I have to return this affidavit, return back to the authorities. So it has come from Jammu. Because I am asked to identify the deponent, my lord. And the affidavit has been shown in Jammu and Kashmir.
4 weeks maximum.
My lord.
At the instance of the counsel to the respondent, the matter is adjourned to after 4 weeks.
22nd April. 2nd April.
And don't come up with
22nd
the
April.
No, absolutely not.
2nd April. 22nd April. 22nd.
All right.
Item 35 for hearing.
Where is Mr. Indrajit Chaudhary?
If it may please your lordships, he has been indisposed since this morning, your lordship. He has suddenly fallen ill, your lordship. So, your lordship, a date may be given for the hearing.
You should have noticed the morning.
Your lordship,
You don't have asked Mr. RTD Chaudhary to be here.
it was subsequent.
He's been here for the last, I don't know how long.
In fact, I was informed it was subsequent to the morning mentioning.
Disposition of Mr. Indrajit Chaudhary and its senior advocate for the petitioner. The matter is adjourned.
Your lordship, a date may be fixed.
23rd April.
Without date, have you seen any order?
Indeed not, your lordship. Your lordship, next week.
Indeed not.
Indeed not, your lordship.
Your date. Convenient date, Mr. Chaudhary will bet the date.
19th or the 20th, 19th or 26th of March. Of this month itself, 19th or 26th. Thursday.
March can be about that. 1st April. 2nd of April.
Your Lordship, Your Lordship, the senior is not available on the second level.
Then Thursday, 9th of April. 9th of April.
Much obliged.